to appeal this judgment.
Cape Division of the High Court in Gqeberha. In order to support the DPP in making this decision, on the 9th of April, 2025, as the National Director, I established a team that led by the Special Director of Public Prosecutions in charge of the SOCA unit, Sexual Offences and Community Affairs. Advocate Bonnie Curry-Gamwell, who I mentioned, is on this platform. Also Advocate Cesar, who is the Deputy Director of Public Prosecutions in the Bishu office, who was part of prosecuting, who in fact led the prosecuting of this case. I appointed 2 other experienced prosecutors from outside of the Eastern Cape Division in order to carefully consider the judgment and the transcript, which runs into thousands of pages, and to provide advice on whether the judgment is appealable or not in terms of Section 319 of the Criminal Procedure Act. As you indicated, Honorable Chair, it is indeed so that as the state, the prosecution can only appeal on points of law and not on points of fact. We also decided that, and in fact appointed independent senior counsel from the Bishu Bar in order to also provide advice on this issue. And the reason why we also got senior counsel involved, which we don't normally do in cases, is that given the criticism that was leveled against the prosecutors in this case, we thought it was really important in order to protect the integrity of the process and to give confidence that we have external senior counsel that peruses the matter, applies their mind, and also renders an opinion on the prospects of success on an appeal in this matter. Unlike convicted persons who can appeal on the basis of fact and law, as I said, the state can only appeal an acquittal on a question of law. The team studied the full transcript of the matter, and they compiled a memorandum of advice. They all unanimously agreed that there are sufficient grounds to appeal the judgment. The team identified several questions of law, which the trial court, in our view, should be asked to reserve for consideration by the Supreme Court of Appeal. They provided extensive motivation for arriving at each question of law. This memorandum of advice was prepared independently of the external counsel's opinion. The team sent the findings to the DPP, Mr. Barry Modolo, who is the decision maker in whether to appeal this matter or not as the DPP in the division. On the 5th of May, senior counsel, having considered all the relevant documents, judgments, also provided an opinion on this aspect. and counsel opined that there are strong prospects of success on appeal. Counsel also identified several points of law for reservation and is of the view that as a first step, it's necessary to request the trial judge to clarify and make available factual findings of the trial court. Once this is done, it may be necessary then to reconsider the identified and proposed questions of law for reservation. But we'll deal with that once we get the judge's clarification of the facts, which we have requested. On the 2nd of May 2025, the DPP informed me of his decision to appeal the judgment and to request the judge to clarify factual findings. The state attorney immediately instructed counsel. The relevant papers were drawn up and they were submitted to the Registrar of the High Court in Gqeberha on Monday, 12th of May 2025. And these papers relate to a request to the judge to clarify factual findings, as I mentioned. And once these are received from the judge, the NPA's legal team will then finalize the papers on the reservation of questions of law and file this application with the Registrar of the High Court. Even though Section 319 of the Criminal Procedure Act does not prescribe a time frame for filing of such papers, we undertake to file the application within a reasonable period to avoid any undue delays in this matter. The decision could not be rushed due to the complexity of the matter and the voluminous transcript that needed to be interrogated also by external counsel. We are of the view that there are reasonable prospects of a successful appeal despite the complexities. The Honorable Chair and Committee will know that whilst the legal process unfolds, Mr. Omotoso has been arrested and is facing deportation proceedings in terms of the Immigration Act 13 of 2002. So that's the steps in respect of the first key intervention. The second one relates to the investigation of the conduct of the prosecutors involved in this matter. So an investigation into the conduct of Advocate Ntelwa and other prosecutors, and I only mention his name because it has been in the public space. An investigation into their conduct started in August of 2024 with a view to identifying any possible misconduct. And as I mentioned, depending on the outcome, whether any disciplinary steps should be taken against any of the prosecutors. Because the judgment on the 2nd of April this year also criticized certain prosecutors, the scope of that investigation has been extended to focus on the entire prosecution team. And if the investigation confirms any possible misconduct, the matters will be referred to the NPA's Office of Ethics and Accountability, which is the OEA, to deal with those cases. In August 2024, and this now I'm talking about, I said that the investigation into this matter had started in August 2024. What happened at that stage is that a senior public prosecutor based in Johannesburg Magistrates Court was initially appointed to deal with the investigation into the conduct of Advocate Ntelwa and other prosecutors, but relating specifically to the mistrial. There might be a question about why this investigation started in August 2024 and not earlier, when it came to light that already in December 2021, that there may have been potential misconduct on the part of the prosecutors relating to influencing the witnesses in the main trial. That is, in fact, precisely why the decision to proceed with an investigation was delayed. It was taken by the DPP in consultation with the late Advocate Rodney de Kock, because the investigation of the prosecutor's conduct required that they will need to get statements from the victims in the main trial. And they did not want to complicate the issue. They were already going through a very complex and difficult time having to testify in the main case. So they decided to wait with the start of the investigations until they had completed their evidence in the main trial. In fact, at the time when the judgment was delivered on the 2nd of April this year, the investigator was in the final stages of the investigation, and I'm advised almost at a point when she could have compiled a report, but it has been now expanded. The scope has been expanded, and I'm expecting to receive the report. I have a timeline on that, which I will advise soon. But what we've done in the meantime, in order to expedite this investigation, is that on the 15th and 16th of April, we appointed additional officials to assist the original investigator because of the extended scope created by the judgment. The additional team members consist of a senior state advocate who has been released to focus on this particular investigation, and another state advocate, both of them from the SOCA unit, as well as a staff member of the OEA, that's the Office of Ethics and Accountability. The team is expected to finalize their investigation and have a report to the NDPP by mid-June this year. The findings from this particular team, as I said, will inform any possible disciplinary steps that need to be taken, and we will closely monitor this to ensure that the finalization is not undue delayed, and that we do meet the deadline of mid-June 2025. Coming to the third key intervention, that was the establishment of a team to assess the prosecutorial performance in the Omotoso case itself. So in light of the criticisms that were made by the judge regarding the seemingly poor quality, in particular of the cross-examination by the prosecutors and failure to adduce corroborating evidence, the NDPP established this team led by Advocate Bonnie Curry-Gamwell, the head of SOCA unit, as well as prosecutors with extensive litigation experience in gender-based violence matters, to meticulously examine the record of the proceedings and assess the performance of the prosecutors in this matter, particularly related to the aspects that the judge raised as matters of concern. This team, which is currently composed of 2 deputy directors of public prosecutions and 3 senior state advocates, they are doing the necessary work. The transcript is, I'm told, over 1,600 pages that they are looking at, and they expect to submit a report to me by the end of this month. Chair, those are the 3 key interventions that we've put in place to deal with various aspects of the Omotoso decision. But I'd like to advise the committee as well that immediately following the decision, the committee will recall that Chapter 9 institutions, that's the Commission on Cultural, Religious and Linguistic Rights, the South African Human Rights Commission, and the Commission on Gender Equality, held a media briefing in which they also criticized the work of the prosecution team and raised concerns about the impact of the acquittal. I immediately reached out to the heads of these Chapter 9 institutions and sought an urgent meeting with them. This took place on the 14th of April at the offices of the CLR. At this face-to-face meeting, we discussed the case. I reaffirmed the NPA's commitment to ensure that justice is done in the case within the confines of the law, and reiterated my, as the National Director, willingness to meet with the victims in this matter. It's important that I, as the National Director, and the leadership fully understand why the victims feel let down by the prosecutors in this case, aside from, of course, the devastating judgment, which we understand. And the reason for this is that as a National Director, I want to ensure that whatever happened must never happen again. We are lawyers for the people. And so we really want to understand this, take lessons, and make sure that any wrongs are corrected. So it's really important. We are engaging, we will engage more with the CLR And hopefully when the victims are ready, they will be able to speak to me. We are committed to cooperating with any envisaged commission of inquiry that is undertaken in this regard. We really, if there's any good, perhaps, if one can call it that, that can come out of this case, is that there is a focus now on dealing with gender-based violence in this country. We know that this is a scourge, and we know that we are not winning this battle. So I think as the NPA, we feel that it will be really important to have a deep dive into why we are not winning this battle. Prosecutions come at the end, and it needs to be an all of society approach to how we can address the scourge. So we really welcome any such inquiry, and we will certainly cooperate and partner to the extent that we need to with such institutions to make sure we get to the bottom of this and fully understand this. Honorable Chair, honorable members, whilst in our appeal, we maintain that the judge has erred in certain of the findings, her findings. As I said earlier, this judgment has had a devastating impact on the victims and has seriously dented confidence in the NPA and in the justice system to address sexual gender-based violence matter. I want to emphasize that although this judgment has been a serious setback, I urge that it does not detract from the really important support and work that the NPA and its partners every day provides to thousands of victims of sexual and gender-based violence, including in the most complex cases. So for the sake of millions of victims in this country, and sadly, potential victims, because the scourge continues, I urge that we do not fuel the narrative that nothing is being done in the NPA to address the scourge or to support victims because of this case, because it is simply not true. More importantly, we really do not want to discourage victims from coming forward and trying to seek justice and from accessing the really good services that are provided. Very briefly, the Tutuzela Care Centers, which are the TCCs, led by the NPA, but in very strong partnership with various government institutions like the Department of Health, the Department of Social Development, of course, the police, as well as, non-governmental institutions, as well as working with business and the private sector, are world-class multi-agency facilities which provide the most comprehensive support to victims on their journey to becoming survivors. Thousands of victims are receiving such support from our country's 66 TCCs, which we plan to expand significantly over the coming years. The NPA achieves a 77% conviction rate for thousands of cases that are flowing through the TCCs every year that are successfully prosecuted. I say this, and again want to emphasize, we do not want to minimize the impact of the Omotoso case, but we urge that it does not detract and deter victims from coming forward to access these services that are critical on the journey to becoming survivors. The TCC is but one of the prioritization initiatives in the NPA that's dealing with gender-based violence. The others include the Serial Rapist Prioritization Initiative, and we can give more details on this if we are required to. We can give reports to Parliament on this. The Teenage Pregnancy Prioritization Initiative, the DNA Prioritization Initiative together, which is being led by the SAPs, and we're working very closely with them on this. In fact, the Serial Rapist Prioritization Initiative, in fact, flows from the DNA Prioritization Initiative. Building of the court preparation capacity, which supports victims through their process to avoid re-traumatization in the court process. Contains sustained public awareness campaigns using different platforms. The building of GBV litigation capacity throughout in the different courts across the countries. Upskilling of prosecutors, which is ongoing, and with a particular focus on trafficking in persons and child pornography. And Advocate Bori Karigamwo can elaborate on this later. And our focus in this particular area, that is trafficking matters, really it is the SABC and the NPA working very closely, and which resulted in South Africa being removed from the trafficking tier watch list in 2024. We have some of the most experienced sexual and gender-based violence prosecutors in the world, sadly, because of the numbers of cases we prosecute, who know how to mount successful prosecutions. And this was demonstrated most recently by the team of advocates Swanepoel and Hiraman, who together with our SAPS investigation team successfully prosecuted the case of trafficking in persons for the purpose of exploitation and kidnapping in the case of the little child Jocelyn Smith, who we really hope will be found soon. Another case involving the successful prosecution was that of a former police officer, Mr. Teku, who has been sentenced to 20 years imprisonment for raping a 17-year-old victim of domestic violence inside the Komka police station in the Eastern Cape. Moreover, interventions in respect of serial rapists that I mentioned earlier on have ensured successful prosecutions of several serial rapists. For example, in the case versus Prince Themba Shongwe, 9 rapes, 4 murders of children between the ages of 11 and 16 years in Mpumalanga. Sexual and gender-based violence remains an unacceptable scourge in our country. It's a crisis that, as I said earlier on, requires the whole of society response. But we understand our responsibility and we take it very, very seriously. And we will continue to provide the victims of crimes with the support that they need and the prosecutorial expertise to ensure that there is justice and perpetrators are held to account. Honorable Chair, honorable members, that is the report on the Omotoso matter. We do have colleagues that can expand on some aspects of this. If the Honorable Chair would allow, we can allow Advocate Boni Karigamwo to expand on some of the initiatives on the NPA. But otherwise, we are ready to take questions, Honorable Chair, honorable members. Thank you.
Thank you. You said it's Advocate who must expand.
Advocate Boni Karigamwo, who is the Special Director of Public Prosecutions in the Sexual Offences and Community Affairs Unit. And she could expand on some of the initiatives in the NPA if the Chair permits, Chair.
Okay.
And we all stand ready to take questions, including Advocate Mr. Madolo.
Okay, let's give him or her to expand, then we give members.
Thank you very much. Advocate Karigamwo, are you ready to address the committee?
Good morning, Honorable Chair and members. So first of all, let me just explain that the soccer unit, or the Sexual Offences and Community Affairs Unit of the NPA, is a policy unit. We are responsible for training and for introducing initiatives to enhance the prosecution of a GBV in the NPA. So some of those initiatives which the NDPP has touched on, and I'll try to be as brief as possible. The most important one, of course, was the creation of the Sexual Offences and Community Affairs Unit, which was established in 1999 to, as I said, ensure that management of our cases by developing best practices, policies, and provide training to our prosecutors, as well as ensure that the NPA and South Africa as a whole complies with national and international obligations. So a lot of our work in the soccer unit really speaks to training our prosecutors at all levels of our courts. We are also responsible for public awareness around gender-based violence, which we also know is quite an important aspect because it speaks to prevention, but it also empowers victims to seek the help that they need. So our focus areas are sexual offences, domestic violence, child justice, maintenance, trafficking in persons, femicide, older persons and persons from the LGBTIQ plus community, really vulnerable people. What we've also, as NPA as a whole we've created what we call vulnerable groups portfolios across all our DPP or Director of Public Prosecutions offices, normally managed by a deputy director, which means all the GBV matters would normally flow through that portfolio committee at a very high level within the province. And they would have with them a litigation capacity, a specialist litigation capacity, who are able to deal with specific GBV crime types. We also have in the NPA court preparation capacity across our courts. And these are persons that have a qualification in social work normally, or social sciences and behavioral sciences. And they are a knowledge, very importantly, of the criminal justice system. And what they do is that at court level, they will speak to all of our victims, all of our witnesses, and explain to them the system and provide them with the necessary skills to deal with going through a criminal justice system, all aimed, of course, at reducing the trauma that they might feel at that level. And we use them not only for children, but for all of our witnesses and our victims. We also have developed strong policy directives in respect of gender-based violence, specifically for sexual offences and domestic violence, Chair, which speak to critical aspects such as bail withdrawals, the actual prosecution, witness management, prosecutor-guided investigation, sentencing. We have also introduced the directives that says that it is now obligatory for all victims to be able to enter our TCCs. So when you get a docket and you see that the person has not received those crucial GBV services at the TCC, where there is one, they will be directed to them. We are also have the Serial Rapist Prioritization Initiative, which we introduced in 2023. So we work very closely with the Serial Electronic Crimes Unit, or SECI unit of the police, and we partner with them both at provincial and national level, where they identify who are the, we call them the top 10 serial rapists in each specific province. And through that engagement with the police, with the DPP office and their specialist unit and the soccer unit, we are able to, once they are identified, guide the investigation and make sure that we are able to prioritize either the enrollment or the finalization of the case. And as a result, we've had several matters being finalized far quicker, serial rapist matters, across the country, and as I said, in all of the divisions. We also have the Teenage Pregnancy Prioritization Initiative. Every year, Chair, we hear the statistics around teenage pregnancies in this country. So in 2024, what we did is we introduced this initiative to facilitate the reporting, investigation, and prosecution where appropriate. For example, in children that are under the age of consent, where we have found through DOH, the Department of Health, or where they present at a TCC, we are then able to make sure that the matter is reported to the police, that a docket is opened, and that there is prosecution of these cases. So we have rolled out this initiative at 38 of our 66 TCCs, and we will continue to roll it out to the other TCCs as well. But that's a strong partnership, as I said, between us, the Department of Health, and the police. We also have had the implementation of the DNA Prioritization Initiative. Chair, you will recall that there was a time where there was a huge backlog of cases of DNA results, which resulted in matters not being finalized or being struck off the roll or withdrawn. We, in collaboration with the FSL of the police, we have since October 2020, Chair, to date, 58,177 reports received through this initiative and sent to the various courts, ensuring that we do not have cases that are being struck off the roll or withdrawn because of a lack of a DNA report. This initiative we will continue with as well. We also have a very, very extensive GBV training material. We do training for all of the our prosecutors across the country. And we train them on all of the GBV legislation. We also, very importantly, give compulsory what we call social context awareness training to all of our prosecutors to make sure that our victims are treated with the appropriate sensitivity. Public awareness, I have spoken to the very, very importance of public awareness campaigns. The soccer unit alone completed just from April to December last year, 853 public awareness campaigns. We also partner with our other stakeholders, such as the police and the DSD and civil society often in ensuring that we get the message across. The NDPP spoke to the initiative around international collaborative training capacity, where we as NPA have partnered with international entities to upskill us in respect of cybercrime, as well as trafficking in persons, so that we are then able to not only prosecute these cases successfully, but also provide training to our other stakeholders in this regard. And this is, of course, a very, very important initiative. And as the NDPP correctly stated, only last year, we were upgraded in terms of the tip tier report and removed from the watch list for the first time. I think it was in 3 years. So those are some of the initiatives which we have. The most important initiative, and of course, we also have the community prosecutions initiative, where we link up with the communities. Importantly, that there are now 50 such sites. I think of that, 26 specifically deal with gender-based violence. So again, showing this prioritization of gender-based violence across all of the NPA. Very importantly, the Tutuzela Care Center model demonstrates really the victim management capacity of the NPA, where we have 66 of them across the country, the first having been established in the year 2000, and we are the only such model in South Africa that provides comprehensive pretrial services for all gender-based violence victims, which is your psychosocial, medical, and legal services, because they are court-directed, which has resulted in, because of all of these services, it has resulted in a conviction rate of 77.5% for TCC matters that have gone through the TCCs. We are on a path, Chair, to make sure, because of the success of this model, a model which addresses our national strategic plan on gender-based violence obligations in respect of both Pillar 3 and 4, we are definitely looking at expanding the footprint of the TCCs across the country as rapidly as possible. Indeed, in 2021, we sat at 55 TCCs. Today, we're sitting at 66 TCCs. So those are just some of the initiatives that we have been able to introduce, and the impact has really been increasing our access to justice for our victims. We've increased our prevention interventions. And as I said, we spoke about the conviction rate. We also have long-term sentences having been increased in respect of these matters, because our victims are able to testify, having been empowered by these vital services that they are given at a TCC. Chair, thank you for the opportunity. Those are some of our prioritization mechanisms within the NPA. Thank you.
Thank you very much.
Chair.
Thank you very much, NDPP. Thank you very much, to your team. Members, can we now interact with the presentation? Of course, the DPP of the Eastern Cape and the Department of Justice will come Honorable Swart, Honorable Breitenbach, Honorable Nomvalo, Honorable Matafa, Honorable Klopa, Honorable Sotetsi, Honorable Dana, Honorable Mutaung, Honorable Mhlongo, Honorable Paulson, Honorable Meshwe, Honorable Shala, and Advocate Sally. Members, in that order, Honorable Swart.
No, thank you, Chair, and good morning to you and to the NDP and colleagues and to the DG. Chair, may I just first make some few comments? We in the ACDP are also very deeply disappointed at this judgment. It is indeed, as you indicated, Chair, in your press statement, an assault on the fight against GBV. And what makes it even more shocking is that the accused was a pastor leading a church, a man of the cloth. And so we also appreciate the investigation by the Chapter 9 institutions into sexual violence in sacred sites such as churches, traditional healing sites. That having been said, I think maybe one of the biggest issues to me is the impact that this judgment has on underreporting, which already exists, of sexual offences, where, as we know, there is already a high level of underreporting, and now one may have victims not wanting to report cases of sexual violence because of lack of confidence in the criminal justice system, secondary trauma, and issues which arose in this trial. And obviously, we, from our perspective, would still encourage all victims of crime to report them. And the NPA is still doing a lot of excellent work in many other cases, such as being highlighted. So this case should be seen in that context as well. I just also want to ask the NDPP and the prosecutors in this matter relating to the issue of what occurred during this trial and how one can take steps in the future to avoid such steps. Firstly, our understanding is that during the trial, the witnesses attracted a lot of unwelcome attention, threats placed in harm's way. And there appears to have been an inefficient witness protection program. The changes in the prosecution team as well resulted in possibly additional trauma to those victims. We know that secondary trauma is a massive issue which impacts upon witnesses, particularly sexual offences, wishing to give and wanting to give evidence. Chairperson, we would strongly trust that this isn't the case that discourages other victims from coming forward and opening cases. But we would really trust that in the longer term, that with the appeal, that there will be a positive outcome to this case. Chairperson, I would like to deal with some specifics of this case, and I do appreciate that the NDP and the team might not be able to answer them specifically due to the impact that they will have on the case, but it is very important that we are aware of what exactly transpired, because it seems that there's a lack of oversight over the prosecutors in this matter. And yes, we welcome the fact that there is an ongoing investigation. We understand the outcome will be given in June. We welcome the appeal, but as you correctly indicated, NDPP, you are limited to the record. You can only appeal on questions of law. No further evidence can be led. So you are basically stuck with the record, stuck with what happened in the case. And we note from the judgment the disparaging comments that were made about the team and the conduct. Chairperson, let me just quickly specify, because I don't want to take up too much time. It appears that these irregularities were during an application came to the light. And I would just like to know, at what time did the NDPP become aware of concerns around the unethical conduct and irregularities, even during the process of this trial? Why was there no intervention when there was an application for a mistrial in 2023 already? At that stage already, there seemed to have been findings about the conduct of the prosecutor being highly irregular and contrary to the principles required of a prosecutor. Why was interventions not taken place at that stage already? Possibly you would have had a much more positive outcome, particularly when it came to the issue of the discrepancies between the statements and the advice that was given by Advocate Serfontein about that discrepancies having to come to be brought to the attention of the court. Chairperson, the issue of the complainants requesting who should prosecute the matter was highlighted in the judgment, where the judge said it is highly undesirable that a complainant can dictate who should prosecute in a trial, especially when a decision was to be taken to remove a prosecutor. And the judge stated that if Mr. Ntowa had been removed at that time, the prosecuting authority intended to remove him, the outcome might have been different. Is it possible, NDPP, to explain what happened in that process of the consideration of the change of the prosecuting team? Because that, the judge highlighted, was an issue that could have had a more positive outcome on the matter. Yes, we now know that the judge was very critical of the cross-examination, as well as the failure of the NPA to provide corroborating evidence. These are obviously all aspects that will be considered. You've indicated you've got a senior counsel's opinion, you've got a high-level team that is looking into this. But again, the challenge is that you're sitting with an existing record. And that is your challenge now. We wish you every success with the appeal, but we would see that there are significant challenges in that regard. Chairperson, could I just then ask, as far as the investigation into the conduct is concerned, is it correct that we'll get a report by June 2025? Or that you would have completed your report and then obviously the process, not necessarily give us the report, but who is conducting the investigation? And one presumes that it will look into the apparent failures, not only of the individual prosecutors, but also the lack of action by senior prosecutors to respond to repeated concerns about irregularities and the apparent failure of ethical conduct. And then could I just ask lastly, Chair, for the Chapter 9 investigation, we might want to have a briefing about that as well, but maybe the NDPP can explain to us how far that has progressed. Have you been asked to prepare? Will there be public hearings in that regard? Thank you for your indulgence, Chairperson, for the time that I took. Much appreciated.
Thank you, Mr. Swart. Honorable Bredenbach.
Thanks, Chair, and good morning to everybody on the platform. Chair, I don't think we've met with the NPA since the passing of Mr. Sambalula, so I would like to just express our condolences to the NPA and to the family of Mr. Sambalula. I understand that the investigation is not yet complete, but it just demonstrates once again that prosecuting is not always an easy job. And then the NDPP started off by mentioning that the NPA are the lawyers of the people. And yes, that is correct. Prosecutors pride themselves on being the lawyers of the people. However, there seems to be very little in this particular matter about which anybody can be proud. This matter was, it appears on the face of it, with the information that's available at the moment, that the matter was handled poorly from the outset. I fail to understand why that is when all the signs for a disaster were there from the beginning. Nobody, not the supervisor of the relevant prosecutors, not the Director of Public Prosecutions, and not the National Director of Public Prosecutions, did anything or took any steps, as far as it appears from the information available, to avert this disaster that really anybody could have seen coming. When you start a trial off by changing charge sheets because of poor preparation, and then failing to discuss those amendments certainly with the defense, then you're looking for trouble. There's disaster ahead, and any experienced prosecutor would be able to tell you that. So what this looks like is a bunch of prosecutors who were entrusted with a very big, very serious, very public prosecution, upon which, once again, the reputation of the National Prosecuting Authority rode, and the prosecutors were clearly not able to deal with this prosecution. They started off badly, proceeded poorly, and they ended off spectacularly poorly. And nobody did anything to assist them, to provide leadership for them, to provide mentorship for them, or to provide direction as a last resort. And so it was, I mean, must have been very clear to everybody that there was a massive disaster looming, and everybody shoved their heads into the sand and did nothing. I find that not only extremely disappointing, but a massive failure, a dereliction of duty. And with respect, it's no good coming to this committee today to tell us about other successes and wonderful practices and world-class institutions that have been implemented and other success stories. We're here today to discuss this matter. And all of those fancy add-ons did nothing, not one thing, to make a success out of this matter that we're here to discuss. So we need to know what went wrong here, why it went wrong, and how you're going to fix it. That's what this is about. So the problems started, as Mr. Swart said, a long time ago, with the issues surrounding the prosecutor in Tilwa. It appears that nobody took a huge amount of notice of those issues, and very little was done to deal with it. Any prosecutor worth their salt, who tries to influence a witness to say or not say anything is not a prosecutor, in my view. Prosecutors are aware, and they're made aware from day one. You do not lay words into the mouths of your witnesses, and you do not try and take away evidence that doesn't suit you. A prosecutor's job is quite simple. It's not hard at all. It's quite simple. You present all of the facts, those that are in your favor and those that are not. You place the court in possession of as many facts as you have at your disposal, and the court will make a decision. That is the job of a prosecutor. And if a prosecutor who's dealing with a matter of this magnitude doesn't know that, then the NPA is in a lot more trouble than we initially estimated. So it appears that there are problems with the behavior of Mr. Nchawa, and I'd like to know, between the time that has passed, what has been done about this? Have there been consequences? What kind of measures have been taken to ensure that this doesn't happen again, not only with him, but with other prosecutors in that area, because this whole team clearly struggled. So there were no one was shooting the lights out in this prosecution team. A failure to lead corroborating evidence in a case like this. Why? Can somebody please explain that? Why was corroborating evidence not led, if there was corroborating evidence? We all know how difficult it is to obtain a conviction in a rape case. In a case of this nature, so much more difficult. That's acknowledged up front. If you have evidence that corroborates the versions of your witnesses, why is it not led? So I would like an answer to that, please. The delay in the case is exceptionally regrettable. It's very difficult to prove old cases. It's much harder to prove old rape cases. And again, we're all aware of the difficulties with cases where sexual assault is the issue. And we're all aware of the kind of tactics that are employed against the witnesses, which also leave a lot to be desired, that make it very difficult for them. We know these things. Rape cases are not easy to prosecute. Rape cases are not easy to get convictions on, for a whole variety of reasons. But making them wait 3-4 years to give the evidence, that's not helpful. Not helpful. It appears quite clearly that there was a sad lack of transparent or effective oversight of this prosecution team. And I'm not suggesting for one moment that Mr. Madolo, who will not have the time to do this, and neither does the NDPP, should keep an eye on every single prosecution. Of course not. But when the matter is like of this nature, when the matter is of this magnitude, when the matter has this much importance for everybody, then surely a little bit of oversight would not have been remiss. Clearly there was none. I'd like to know why there wasn't any, especially in the light of the allegations of unethical or irregular conduct by the prosecution. There appears to be no accountability. Things went wrong from the beginning. Very little, if anything, appears to have been done about it. And there appears to have been a lack of application by a whole variety of people, yet they remained involved in the case. I don't understand that, and I'd like an explanation. For instance, there was a prosecutor, Sir Fontaine, who brought irregularities to the attention of her superiors. Apparently nothing was done about it. Why is that? Why did this team of prosecutors and the team surrounding them and the people who it was reported to think it was okay to plaster over alleged unethical and irregular conduct by prosecutors? That is the one thing that no prosecution can ever countenance. Prosecutors have to have unimpeachable integrity. They have a lot of power, and they have to have unimpeachable integrity. And if they don't, then something needs to be done about it. And it doesn't appear that anything was done here. I really don't understand why, and I want to know why. And then this internal investigation now, of course, I suppose is necessary. It's taking inordinately long, and I understand the issue of the complainants not being questioned at the time. But what it's in fact doing now is it's rubbing salt into the wounds. They had to wait years for their day in court. Having had their day in court, they were not believed, and the accused was acquitted. And now they have to be subjected to multiple traumatic experiences of retelling that story over and over and over again in the internal investigation. The whole thing is unsatisfactory. It shouldn't have happened, shouldn't have been allowed to happen. And somebody along this line of command is responsible for allowing it to happen. And I want to know what's going to be done about accountability for that. The Office of Ethics and Accountability in the NPA, I would like to know a little bit more about that office. What does it do? What's its mandate? How many complaints does it have in a quarter, more or less? And how are they dealt with? And I sincerely hope that the Office of Ethics and Accountability is not just a renaming of the old Integrity Management Unit, which was an oxymoron. The poor quality, apparent poor quality of cross-examination, that just smacks of a lack of experience, and if that is the case, and I can think of no other reason for very poor cross-examination, except a lack of experience, unless it's a lack of preparation and application, which I would hope it wasn't, then I would really be interested to know why these prosecutors were dealing with a matter of this nature. And was there not another team of prosecutors somewhere in the entire NPA who were better equipped to deal with a matter that was going to attract this much attention? Then, well, there's pages and pages. I'll try and cut them a bit short. The prosecutor has a WhatsApp group with all the complainants on it. That's nothing short of bizarre. Why do you have prosecutors who are considered senior enough to prosecute a matter of this nature, of this importance, of this much public interest, who think that it's okay to put a group of witnesses on one WhatsApp group when it's the most basic thing in prosecution that your witnesses are kept apart, that they don't discuss the case, that they are never allowed to influence each other in their evidence? I mean, what is this, a WhatsApp group? And what is the explanation for it? It's bizarre. It's nothing short of bizarre. Again, the poor cross-examination in a matter like this is unforgivable. There can't even be an acceptable explanation. It's just unforgivable. I'd like to know, Mr. Swart already asked about when the DPP and the NDPP became aware of this whole situation. I'd like an answer to that, and I'd like to know what they did about it. And what is the position with regards to the two adverts, Gabadan and Gandon, who were informed of these issues with witnesses and charge sheets quite early on, and it appears nothing was done about it? What is their explanation for their lack of action? And given this mixed pot of unfortunate occurrences, why is it that the DPP or the NDPP, at a much earlier stage in this trial, did not see this disaster descending upon them and take steps to avert it? How is it that the whole matter was allowed to run, one mistake compounding the other, and nothing was done to provide guidance, nothing was done to rectify, nothing was done to ensure that the prosecution was handled in a better fashion? It really does leave one feeling dissatisfied. I have many more questions, but I'll leave it there. I'm sure somebody else will ask some of them. Thank you, Chair.
Thank you, Honorable Nomvalo.
Thank you very much, Chairperson, and greetings to the members of the committee. Chair, I think it's important that I emphasize the fact that some of us are not going to be disarmed and be diverted by peripheral self-glorification by the NPA, which is coming with all peripheral issues of their initiatives and so on and so forth. We will deal with such in a relevant meeting. they were summoned to this meeting to come and give an explanation of how they have dealt with the Omotoso case. And that is our focus. So we're not going to be disarmed and defocused. Our focus is on the Omotoso case and how the NPA has conducted and has played its supervisory role in ensuring that it scores success in this case. And furthermore, Chair, I think two narratives have been vindicated here. The first narrative is the narrative of the MK Party, the organization which I represent, that holistically, the NPA, because of its weak incumbent, is weak and is an impediment to a successful prosecution of critical cases that should be thoroughly prosecuted in favor of the victims, in particular in this context of the victims of gender-based violence. That is number one. Number two, the narrative that has been vindicated here is a societal narrative and a narrative from the SABC, which is at the entry level of the value chain of the justice cluster, that they do their work to the best of their ability. But the work that they do is always sabotaged by the NPA because they arrest accused today and on the following week, they are released because there has been no successful prosecution. That is number two. So the police here, in our belief, tried their level best, their highest level best, to do their work, because in the report that has been tendered here by the NPA, there is no concern on the work that was done by the police. Whenever we've not been told of a document, of a docket which came with defects, but the demise here is solely on the incompetency of the NPA. So the police here have been failed. Before I even go to how the accused have been failed. So we are vindicated as the MK Party, and this justifies our call for the immediate removal of the current NDPP advocate, Batoyi. We've been making that call that she must vacate the office with immediate effect. And we're not shocked, by the way, by these outcomes and by the judgment which has been given on this matter. Because we once asked about a very prominent case when Advocate Batoyi appeared on this committee. And she said to us, she doesn't know about that case. A case which is broadcast, a case which appears on the media on a day-to-day basis, a case which is being heard in a province which has a scourge of political killings, the case of Cindy Somakak. He came here and she said to us when she was responding, she doesn't know, she will ask her colleagues or her subordinates about the dynamics of that case. So that is why we are not shocked that today we are sitting here in this committee getting this incomplete report. And I'm saying that the report is incomplete because the report tells us about how they are reacting to a judgment of the court. It is not sequential because we were expecting a report which was going to tell us about from when the docket was handed over to the NPA. To say, we received a docket of this nature. This is how we advise the investigating officer. This is how we proceeded with the matter. Chairperson, it was clear, even to a lay person, that the prosecution is going to fail the victims on this case. I can remember with a vivid memory on the first day of a trial, when the matter was heard in a PE in Gqeberha court. the prosecutor who was there in that was failing to execute, was failing to protect the victims against an unfair cross-examination. He failed dismally, and there was a public outcry in that regard. That is when an efficient and that is when an incompetent NDPP was supposed to realize that we're having a serious problem here and we need to intervene with immediate effect. You were not supposed to wait for the court to tell you that the people whom you are supervising, the people whom you have a statutory obligation in terms of Section 22 of the NPA Act to supervise, have failed their responsibilities. If you were an efficient and competent NDPP, you were supposed to pick up that from when it was happening in the NPA. Like I'm saying that even lay people had concerns on the manner in which the prosecution was done on the first day of a trial. On the first day of a trial, the prosecutor could not even intervene, could not even raise objections. So if we were taking these cases serious, we would not be here today. We would not be discussing the judgment. The case would have been successfully prosecuted and the victims would now be rotting in jail. Today, the perpetrators will be rotting in jail. But the opposite is happening. The perpetrators are going back to their homes, are going back to lead their bogus churches, and the victims are crying literally for justice. So we're going to make sure that we intensify our call as the NPA for the removal of Advocate Batoi. And if she cared enough about the people of South Africa and about the NPA, she would have by now voluntarily removed herself. She would have voluntarily vamoosed from that position, because there is nothing that she can point at and say, this is what I have done to turn around the institution. Chairperson, what I want to ask here is, when you appointed the prosecutor for this case, the first prosecutor, what considerations did you make in terms of the skills and the expertise? Because remember here, this was not an ordinary case, and this is a case which actually was giving you an opportunity as the NPA to showcase the strength that you have. Because remember, there is loss of confidence in this entity. No one has confidence in the NPA, besides perceptions that the NPA has been reduced to a ball that is used to play political football. But in terms of prosecutorial work now, on a day-to-day basis in court, no one has confidence that they execute their work with the best of their ability. Now, what considerations did you make when you appointed that prosecutor who was handling the case? Two, I vehemently disagree with your logic of saying that you did not initiate investigations because a trial was underway, and an investigation, had it been initiated when the trial was underway, was going to tamper with the trial. I vehemently disagree with that, and I think that is where you lost it. Besides the fact that you failed completely and dismally to execute your statutory obligation, but in this context, you failed because you were supposed to initiate the investigation immediately after the complaints were brought to your attention. Because you were going to be able to identify the defects and cure them so that the prosecution is not going to proceed with those defects. But you allowed prosecution to continue under that cloud. And as a result, it compromised the prosecutorial work. So I completely and vehemently disagree with that logic. You should have handled this matter better. So if I was in a position, or if I was at liberty, I know that that it will be off context. But if we were given a choice of either accepting or rejecting this presentation, I was going to reject it because one, it's a microwave presentation. They have cooked a presentation. It's an after-the-fact presentation. It does not give a sequential explanation of how the matter was handled from the word go until the judgment was given. Who was the SPP, how the matter was supervised, how many reports were tendered to the NPA about this matter. All we are hearing here is the appointment of senior advocates, is the appointment of so-and-so to investigate this. We're not interested in that wasteful expenditure, because that is wasteful expenditure. It's wasteful expenditure because you are investigating matters that should have been detected during the course of the prosecutorial work of this matter. It's wasteful expenditure. So this report, Chair, we vehemently denounce it. And if we had liberty, we were going to direct the NDPP to go and compile a conclusive report in this regard. Because this is not a report, what we've been given here. It's a mini-skirt report, a microwave report, which lacks sequence. It doesn't give us a full insight of what transpired in the case, who was at fault. So, Chairperson, I'm very disappointed, and I'm not shocked for being disappointed. I've prepared myself for being disappointed today, because at no stage where the NDPP has ever come to this meeting and tender any progressive report. As usually, we have indicated that this work has not been done properly. And here, the only people we worry about and whom we sympathize with are the victims. Thank you very much, Chair.
Thank you, Honorable Nomvalo. Honorable Matava.
Thank you very much, Chair. Good morning, Chair, members, the NDPP and the team and guests on the call. Chair, let me start first by sharing the sentiments on the disappointment over the outcomes of this particular case and the potential impact that it has on victims of sexual offenses, as well as on the image of the entire justice system. Chair, maybe let me align myself with Honorable Nomvalo in terms of the expectations of the report. And I think as I proceed to pose my questions, you will realize what, when I prepared for this meeting, was hoping to get out of the report. Because my understanding was that we are reflecting on the very shocking outcomes of a 7-year-long case where victims have been disappointed by the performance of the prosecutors. What led to that particular outcome? And in the process, what were the failures or lack of action that maybe the interventions as being proposed by the NDPP would come in and maybe have become part of the report? And by the way, Chair, for the purpose of going forward, I, for one, support all the stated interventions that are being put, but that is in a way of looking into the future. Now, Chair, on this case, the main impact, as the judge would have stated, was the poor cross-examination. But it also, the judge also reflects on lapse of judgment on the side of the NPA, inaction, and I think also systematic failures. So that is why my questions will also focus on the case, but also speak to the operational efficiency and capacity of the NPA. Because my belief is that this case might be just the case that will assist us strengthen the NPA or help it to reflect on itself. Now, Chair, I'll start on a point to find out from the NPA, and I think Advocate Bredenbach touched a little bit on this issue of categorization. Does the NPA have a system of categorizing cases in terms of maybe high priority or high profile, or maybe just routine and ordinary cases? Now, I'm asking this question, Chair, because when the president declares sexual offenses and GBV and F as a second pandemic, automatically a case of this nature becomes high priority. Now, the question is, if this was a high priority case, what was the role of the DPP in the Eastern Cape in terms of oversight in this particular case, especially as it led to the time where the cross-examination was to be undertaken? Because I believe that such a serious case would require a thoroughgoing strategy which would have been guided and prepared at the highest level. And I failed to see that role until such a time that there was replacement of prosecutors and Mr. Madolo was brought into the picture. Now, linked to that, Chair, a direct question: is there an accountability framework in the NPA? And if such exists, I will implore the committee to ask for a report to see what the NPA has done on issues where there were serious allegations against prosecutors. Chair, I'm raising this point because there are serious allegations against prosecutors where they might have misconducted themselves to an extent of asking witnesses to perjure themselves. And there would have been cases that were reported in the media where serious allegations of gross dishonesty and misconduct were raised against prosecutors. Now, the question begs, when such allegations are made, what does the NDPP say? What does the DPP in the area where this allegation is made say in this regard? Second to that, Chair, is just to find out if whether are there oversight mechanism between the NDPP and divisions. Because my view is that if there exists oversight mechanism, red flags should have went up long time ago as far as this case is concerned. When an application by the defense for a mistrial came up, questions were supposed to have been asked. Charges being reduced from 63 to 34 or around that, flags should have been raised. Allegations of misconduct by some of the prosecutors, and obviously the length that this case has taken, the multiple postponements would have triggered a response or a reaction from the highest office to ask, why is this case dragging for so long? And when it's actually a case about a serious matter like sexual offenses. Now, Chair, the other point that I hope that the report will cover is when the investigation that is being currently undertaken, how will those that are in the employ of the NPA be protected from victimization? And I'm asking this, Chair, because the judge speaks about the issue of a senior prosecutor asking witnesses to perjure themselves, a junior prosecutor raising this concern, an observation with those that are senior to her, and that is Advocate Serfontein, and nothing was done. Now the question becomes, should there be a situation where Ms. Serfontein is required to come and assist the investigation? What measures are in place to ensure that she's not victimized and she is shielded from any form of victimization? Because the mere fact that she stood up and spoke against her seniors will put her in a very difficult situation going forward, even though her plight at that time was ignored and the prosecutors concerned were allowed to proceed. Now, Chair, linked to the initial point of the accountability model, I'm also interested to find out if whether is there a clearly defined complaints process when allegations of misconduct are raised against prosecutors. I believe that when the allegation by Mr. Fontaine, and which were proven, were raised, and those allegations were put through a particular defined process, the person who was accused of making that particular intention to have witnesses perjure themselves would have not proceeded with the case. That's at least what I believe. Chair, maybe I'm going too far, but a direct question. Is there an investigation to see if whether the assassination of Ms. Pamela Mabini is in any way linked to this case? We know that she was very vocal, and in the public space, there would have been allegations or sentiments growing that her assassination could have been a way of intimidation, either to witnesses or any other concerned party that might have wanted to play a role in such a case or in others going forward. Because we all know that when she was assassinated, in the very same month, there would have been another assassination of an activist against GBV and sexual offenses. The effectiveness of the Office for Witness Protection linked to the case that I would have alluded to now. How effective is this office? Is it being properly promoted enough amongst witnesses and whistleblowers? And if so, can we maybe be given maybe stats in terms of how many are on it and what can I call, not advertising, but outreach programs to make sure that this particular program is known, so that those that can benefit from it are then allowed that opportunity to come in. Chair, my last point is on the issue of training for prosecutors and all and sundry in the NPA. I view the response by a 14-year-old veteran prosecutor that they do not understand digital penetration, which is non-consensual, as rape. So the question begs, how do we continue enhancing and improving the skills of those that we trust to litigate on behalf of victims of crime in this country? So training for me is very important. So I'm interested to find out what training is there, what measures are there to improve the effectiveness and knowledge of those that are responsible for ensuring that the voice of the victims and South Africans as a whole are heard in such cases. Thank you very much, Chair. I will pause there. Thanks for the opportunity to participate in this discussion.
Thank you very much, Honorable Klopper.
Thank you, Chairperson. Firstly, I'd just like to express my deepest sympathy with the victims of the case. I think their courage to come forward must never be in vain, and today we honor them really by asking these difficult questions to the NPA. A lot of the details have already been covered by previous speakers, So I just apologize for any overlap that might actually occur. Chairperson, firstly, there was a piece that I didn't hear properly, so if I could just get clarity. Apparently there is the investigation taking place currently, and the two advocates, I think it was two advocates that are involved, are also from the soccer unit. Is this the same unit that Advocate Ntelwa is part of? Chairperson, my first question is, how did the senior leadership within the NPA allow prosecution of such national significance to proceed in face of the procedural irregularity? Sorry, there was unamended indictments, unethical conduct, incomplete presentation of evidence. At no point in the 8 years did anybody in the leadership step in DPP, NDPP intervene. Were they informed of these irregularities as the case went on? And if so, why didn't they do anything, while the trial was on? I think it's very important in this case specifically that on the very same day of the acquittal, an NPA prosecutor, Ignatia Malakwane, appeared in the court on charges of corruption, extortion, and obstruction of justice. And the coincidence is not just disturbing, it signals like a possible leadership vacuum. Because the chairperson, this cannot just be accepted. Chairperson, I understand that there is a disciplinary in process, and I think it's going to actually hamper a lot of the questions. What I would like to know is the superiors that found out about all the WhatsApp and the police statements and the witness, witness statements that were told, that they need to stick to the police statements and so forth. Why wasn't this matter specifically addressed, when it happened? I understand the MP said that they didn't want to do inquiry while the case was ongoing, but that specifically, why wasn't it addressed? Because it would have massive impact. And, I also would like to know, what support exists for the NPA and for the victims in these high-profile cases specifically? And I mean, this is an 8-year ordeal. And these witnesses had to go through this for 8 years. Judge Kuman dismissed 31 charges because there was no evidence being led. I mean, this is extraordinary failure. And what message does it actually send to the survivors of sexual violence? The NDPP, said we shouldn't discredit, all the work being done. And, and while there might be very positive cases, that's no dispute. But, when you're the victim and then you become a victim of a failed prosecution, other successes don't matter to that victim. And I think that really needs to be, very, very strongly considered. The internal audit is going on, and what happened and who's guilty and who's not. And I'm very sure that this will be made public, made public. What worries me is in the last year that I've sat in this justice portfolio, we've heard many reassurances, so please bear with me. When the TRC matters came to the committee and the victims, they were felt let down by the NPA. We've heard of corruption trials that just don't take place, and it affects millions of South Africans. And now the cycle continues to very serious offences like the sexual offences. And Chairperson, it's not that I somewhat believe that this isn't only about this one trial anymore. It's about prosecuting authority that appears either incapable or unwilling to confront some internal rot that exists. And until these failures are addressed at the root, I think the NPA will continuously bleed. And I don't understand how they wish to restore this public faith in the justice system and in the NPA when they're continuing to let down South Africans. And I must say again, I reiterate, in no way am I saying that there isn't any positives, and I'm not saying that there isn't cases that were successfully prosecuted. What I'm saying is it doesn't matter to a victim that was let down by the NPA, and especially in such a serious matter, and especially when it comes to gender-based violence. Chairperson, I won't go further. I think many speakers have spoken and they've covered a lot, and there's many speakers still to come. So I'd just like to pause there. Thank you, Chair.
Thank you, Honorable Tsotetsi. Honorable Tsotetsi. Okay, let's pass. Honorable Dana.
Thank you, Chair, and good morning, and thank you for the presentation. Sure. Chair, poor cross-examination, amateur mistakes, unethical conduct in such a high-profile case, it's, to say the least, very, very disappointing. And even if it wasn't a high-profile case, it shouldn't happen in any case at all. So yeah, many of my questions have been covered. I just have two more. The one is with regards to the delays in finalizing the case. It wasn't only the fault of the NPA, but in this to and fro and during this long time lapse, things did fall through the cracks. So we know our criminal justice system is broken at best. The NPA can only do what you can. But work can't continue to be done in silos, and we've seen this now since forever. We've spoken about this in so many meetings, and it's all to the detriment of the victims of the crimes. Work is being done in silos in the criminal justice system, in the cluster, and I'd like to know, are there any attempts or plans from the NPA's side to address these gaps between the different role players in the criminal justice system? So that's my first question that I've not heard any colleagues ask. And then the second one is, we know the NPA has many successes, it's not only losses, and we commend you for that, because the prosecutors especially work under very, very difficult circumstances. And on that point, I'd also like to express my condolences with the family and the colleagues of the prosecutor, Mrs. Sombulula, who was murdered recently. But the loss, Chair, of any case like this, especially with a scathing judgment like this one that was handed down, is one too many. So we welcome the consequence management that has been proposed or that has been initiated already by the NPA, but it's too late for the victims of these crimes. They are suffering secondary trauma. It's completely unacceptable, especially with the drive that we have against GBV in this country. We cannot allow something like this to happen. So what I would like to see is, or hear, and then eventually see, is an absolute insurance that everything possible will be done to prevent something like this happening again, whether it be in the training of prosecutors, in the oversight of prosecutors, in the performance management of prosecutors. Everything absolutely has to be done, and we want the insurance for that. I think I can speak on behalf, and no, I'm not allowed to speak on behalf of the committee, but I'm sure that's what everyone wants to see. We cannot, this is such a disgrace, this is such a shame, and it's really disheartening to hear all of these things, amateur mistakes being made, and especially in a case where someone with such a high profile, someone in a position of power is acquitted, and the victims are being traumatized over and over and over again. And I think it was Honorable Swart who alluded to the fact that this is going to have a direct effect on reporting, especially where someone in power is the perpetrator in cases like this. So that's all for now. Thank you, Chair. If there's anything else, I'll raise my hand.
Thank you, Honorable Dana. Honorable Tsotetsi. Okay, let's pass Honorable Mtaung.
Thanks, Chair, for the opportunity. Chairperson, I think most of my colleagues, they have already mentioned many points in this presentation. But Chair, I must just say that we are very disappointed of this case. Not only disappointed, we are even ashamed to talk about it in the public space. It's a very big embarrassment for our justice system, Chair. My only question, Chair, to the NDPP is that what is it that the NPA is doing to protect whistleblowers? Because I don't think we are doing justice as government to try and protect our whistleblowers that are assisting the government in different cases. Thanks, Chair.
Thank you, Honorable Zodezi. Let's pass Honorable Mhlongo.
Thank you, Chair. I want to say that firstly, the NPA should really hang its head in shame for not only failing Cheryl Zondi and all the women who have been raped and violated by Omotoso, but they should be ashamed for their daily persistent failures in the different courtrooms across the country to the victims of rape, attempted rape, gender-based violence, domestic violence, and femicide. Now, the failure of the NPA to ensure that Omotoso is successfully prosecuted will make more women afraid to come out, for they know that they will be failed by the NPA and they will never find justice. So we must not shy away from raising that fact. That is now a fact that women will be very scared to come forward on such cases, especially when they have to go up against such powerful individuals like Omotoso, powerful individuals who are perceived to be men of the cloth, who are running big churches like this. Now, you will remember, Chair, that Cheryl Zondi was a little girl at the age of 14 when she was raped and her childhood stolen from her by Omotoso. She bravely testified in court for the whole world to see, yet the NPA has failed her and the girls and women who were raped by Omotoso or who were sexually violated. Now, Advocate Batoyi must tell us what kind of a message does the NPA want to send to young girls and women in South Africa about not only their safety, but their cry and need to find justice when they are violated. Now, Judge Skuman in the judgment delivered a scathing judgment on the actions of Mr. Ntwela, Gobedan, and Gordon on their irregularities and their conduct. Now, if you check paragraph 40 of the judgment, it portrays a miscarriage of justice. The prosecutors were unethical and incompetent. Those are the words used by Judge Skuman. When the lawyers of the state are incompetent, it leaves the victims vulnerable. Where should victims go when we have incompetent and unethical lawyers of the state who are supposed to be, as Advocate Batoyi explained, they are lawyers of the people. Now, in paragraph 47, Chair, we read it, we saw that the judgment labels the cross-examination of accused number 1, Timothy Omotoso, as desultory and in the extreme. It says that there was no thought that went into cross-examination. And it further says that cross-examination was shallow and lacking the intention to uncover the truth. That leaves little to be desired, and it says a lot about the NPA. Maybe as I quote lastly for from the judgment, Judge Skuman further finds that the cross-examination of accused 2 and 3 actually amounted to no cross-examination at all. Now, this begs the question, this cross-examination and this whole trial of Omotoso was broadcasted live. I do not understand how the NPA could not pick up the problems to actually begin with. I'm really lost how they could not pick up that there's a problems in this case when it was broadcasted live for all to see. Now, NPA should really be embarrassed after having failed all of us as women and the girl child of this country. You know, after the judgment that was delivered, they should have gone, perhaps tried to save face by going to or putting up a proper appeal case. As they say, they want to appeal this matter. So we're hoping that they save face and perhaps put a solid case on this matter. And I want to know what guarantees are they that when they appeal and what measures are they putting in place to ensure that when they appeal, Omotoso does not apply for a mistrial, how best to ensure that we safeguard this case and we don't lose it in terms of NPA does not lose the case and on the basis of a mistrial. Perhaps Omotoso saying there's a double jeopardy on this matter. Now, soon after the judgment, NPA says they are trying to save face. They get SABC and Home Affairs to open a case on the matter of Immigration Act. We get embarrassed again, Chairperson, you know, as the country and all of us who are interested in issues of gender-based violence and femicide in this country. And NPA itself gets embarrassed. We even fail on small technical issues. I don't know why the NDPP is mentioning that case of having arrested Omotoso, because they failed to deliver the man in court within 48 hours as stated in the Constitution of the Republic. He could not appear. So we're failing even on small issues, technical issues, Chair. I'm worried about this case when we fail on a small technical issue. Now, did the NPA get an explanation as to why a WhatsApp group was created for the witnesses and why the content that was posted in that group has since been deleted? Is this a norm that witnesses in a case get to be put in a WhatsApp group? If not, why was it done in this case? In fact, Chair, the way things are going with this case, I'll not be wrong by assuming that the NPA finds joy in repeatedly triggering and doing secondary violation to women and children by their consistent failure to prosecute accused in cases of rape, gender-based violence, domestic violence, and femicide. Now, perhaps, you know, Chair, I was listening to the NDPP trying to pacify all of us here, telling us about cases they've won. She does not mention similar cases where the state has lost because of the incompetence of the prosecutors. But because we are being pacified, we are being managed, Chair, we are told about cases they have won. We're not interested in those cases. Thank you, cases you have won. There was justice for the witnesses. We are concerned about the cases you lose. We are concerned about this case of Omotoso. Another disturbing factor, Chair, in this case is now the death or the case where Ms. Pamela Mabini, the whistleblower on this case, was killed a few weeks before the judgment was delivered on Omotoso. More interesting, the person that the police identified as a person of interest in this case has also since been killed in a taxi rank in front of many people. So this indicates to us, we are wondering if this is linked to the case of Omotoso or it's linked to another case. So this is another case that we'll be watching with keen interest as the economic freedom fighters, because we're interested in knowing if the killing of Ms. Pamela Mabini was linked to this case of Omotoso, and if this will not be another case that SABC fails on it and labels it as a cold case, or SABC will do their job, hand it over to the NPA, and will again have incompetent prosecutors who will ruin this case like they've done with this one of Omotoso. You know, Chair, I'm aggrieved, I'm annoyed, I'm angry at the fact that the NDPP says that in her report, like the rest of us, that they are shocked by the judgment. They can't be shocked about the judgment. We are where we are today because of the incompetence of her own prosecutors in her office. So it's not true that they are shocked. They are not shocked. Everyone could see when the case was ongoing that there's a problem. You know, on paragraph 5.2 of the presentation by the NDPP, it says that investigation into the conduct of Advocate Ntlelo and the other prosecutors involved in the Omotoso matter started in August 2024. Yet there's no report that has been finalized on their conduct to this day, Chair. So I want to know, since they are still busy with the investigations, the prosecutors that they are investigating who are involved in this matter, a very sensitive matter that seeks to that has tarnished the image of the NPA. Are these prosecutors still at work? That's number one. If they are still at work, do they still get allocated cases of rape, attempted rape, gender-based violence, domestic violence, and femicide? If so, why? Are they suspended pending the finalization of the inquiry? If they are suspended, are they suspended with or without pay? And if they are not suspended, they are still reporting in the office. I'm interested in knowing, what do they do on a daily basis? Today is a Friday, is a normal working day. If those prosecutors are still in the office, what is it that they are doing to ensure that they also do not jeopardize this investigation into their conduct? Now, I want to know also from the NDPP, on cases of misconduct and irregularities of prosecutors, how long does it take to investigate and have a report on a matter? Do you perhaps give timelines on matters like this or not? If you do normally have deadlines or timelines, was the deadline to finalize this report submitted, given to the investigators? Since the report and the investigation started in August 2024. If not, why not? If it was given, was it met or was it not met? If it was not met, why not? Does the NPA have mechanisms in place to track proceedings of cases allocated to prosecutors, or you only pick up problems with the way a prosecutor was handling a matter after a judgment has been delivered? Now, Chair, I want to raise another matter. Also Judge Skuman, I don't think should be spared from this, because in her judgment, she makes the victims to somehow look like they are to blame for the failures of the NPA. Now, Chairperson, another thing we're interested on is we need perhaps, to get the Department of Justice and Constitutional Development to review the way cases like this, cases of rape, attempted rape, murder, gender-based violence, domestic violence are handled. We need to amend certain sections of our constitution, because I tell you for free, it's a pity how the first 3 court appearances of an accused person on a sensitive case of rape, murder, attempted rape, domestic violence, the first 3 or even more appearances, the justice is only interested in one person, is interested on the rights of the perpetrator or the rights of the accused. First 3 or 4 or more appearances of the accused when they appear in court, we are only talking about their right to get bail. Nobody is interested about the victim. Nobody cares how the victim feels. It's an indictment on our constitution, Chair. It tells us that something must be done. It ought to be changed. And the way questions are posed to victims of rape and gender-based violence or sexual assault in court leaves little to be desired, Chair. Witnesses are asked to recall what they were wearing, what their victim was wearing. Chair, sitting here, I don't remember what I was even wearing on Monday. It's not something I can remember. There's no, people have other things that they are busy with in life. And after being sexually violated and traumatized like that, I don't think it's easy for victims to actually recall and remember everything that had happened to them. Lastly, Chair, as we sit here today, we're speaking about this matter, and I heard that they were mentioning that they are prioritizing DNA. As we sit here, Chair, the SABC Forensic Lab in Pretoria office, the roof is leaking, the building is in a dire condition. The whole upper floor of forensic investigators for weeks has not been reporting for duty. And this contributes to the continuous failure or delays of evidences in order to resolve cases of rape, murder, and similar cases. Yet we are made to believe that there's a will to resolve such sensitive cases, while evidence continues to be compromised and delayed. Now, the backlog that is going to come from that office, I know it's not the fault of the NDPP, is now an issue of SABC, but the disaster of the backlog that is going to ensue from that office is going to delay a lot of cases that are with the NPA, Chair. And this is really a problem for us. So please, Chair, let's not allow the NDPP to pacify us and seek to manipulate us in telling us about cases they've won. Let's hear about the cases they have lost. How many cases they have lost, and what have they done to those people who, those prosecutors who lost cases because of their incompetence and their irregularities or their misconduct in handling the cases. So we must not be pacified by cases that they've won. They ought to ensure that they win cases. It's their job as lawyers of the people to win cases on behalf of the people. So we must not be drawn into perhaps be asked to clap hands for a swim for fishing. We are more concerned about the cases that they are losing and their failures.
For a fish for swimming, Honorable Mhlongo. You said for a swim for. You said for a swim for a swim for fishing, for a fish for swimming.
Yeah, a fish for swimming. No, yeah, no, it can be that we're clapping for a fish for swimming. Winning cases is part of their job. They ought to do it. They ought to win the cases. So we are not going to clap hands for that. We are going to call them out when they are busy losing cases, especially high-profile cases like this, Chair. So I'll leave it there, Chair. Thank you.
Chairperson.
Thank you, Honorable Mhlala.
Thanks so much, Chairperson. Let me take the opportunity and greet everyone present in the meeting today.
Mhlala, it's not you now. I thought there is a point you wanted to raise.
Okay, let me come to that, Chairperson. Allow me to speak. Okay. I'm taking the opportunity to greet all members present in the interest of time, and I will proceed by saying all protocol observed. Chair, I was calling order really to you. The fact being that when you came to us, you changed the sequence. You started thoroughly from number 1 until I was listening because I was writing when you took the names of the people that must come following each other. But when you come to us, it was Honorable Nazir Paulsen and it was myself and then Honorable Mohlongo. You then started with Honorable Mohlongo so that when we address this issue, we become disorganized as members of the EFF as if we are fighting amongst ourselves. Of which you know very well that the first person to speak here was Honorable Paulsen, of which I've spoken to Honorable Paulsen. I will start first before Honorable Paulsen come. So please allow me to present in that regard, Chairperson. But really, I see you being genius. It was Honorable Paulsen. I don't know why did you call Honorable Mohlongo. Honorable. Of calling Honorable Paulsen, myself,
Honorable Mhlala, we are in the Mosha leadership. We are in the Mosha because that's not even a point of order. And I would plead to you to allow me to chair and direct the speakers, and everyone is going to speak here.
But it's a point of order, it's order. Because you have changed the whole sequence of how you were calling people.
Honorable Mhlala, please
just started by calling Honorable Mohlongo instead of the sequence. Because you want to disorganize us.
No,
but it's fine. I'm allowing you to chair the chairperson. Proceed.
And Mosha, Honorable Mhlala. And Mosha.
Who else Mosha, Yolan? And we are not going to allow that if uzodlala politics because
I can even start. Actually, I can even start from the bottom. I can even start from the beginning. Please don't do that. Honorable Paulsen.
Thank you very much, Chairperson. Chairperson, I would actually like the permanent member representing the EFF to go before me. I think it's
But Chair, can we have order, man? I don't understand why members of the committee want to chair with the chair. There is an order which is there's a directive which the chair is issuing that people must speak. Now we must be subjected to people determining who must speak before who has to speak before who. This is out of order, and I would like you, Chair, to really defend on this.
Yeah, that's order is sustained, Honorable Tsotits. You know, I've even skipped you when I called you and you did not respond. And there's really no issue about it. There's really no issue, and there's no issue even about a disorganization here. There's no one who's being disorganized here. We are discussing this critical matter. Can we please proceed as per how I have appointed out speakers, please, members? Honorable Paulson, can you please proceed?
Chairperson,
No, wait, Honorable Hlal, wait.
can I come in?
Oh, no, wait, don't come in.
Okay,
Honorable Paulson, there are two issues, Honorable Paulson. Is either you are withdrawing or you proceed.
I would really not like to withdraw. I have.
Yes, please proceed.
Thank you, Chairperson.
Honorable Mhlala, I'm still going to come to you. Proceed, Honorable Paulson.
Thank you, Chairperson, and once again, Chairperson, and to the members of the committee. And Chairperson, I was covered mostly, but there's one particular issue, or three actually, to Ms. Bonnie Karigamo, who heads up sexual offences and community affairs. So, and another member did cover this partially. On the 7th of March 2025, a community activist and a whistleblower in the Omotoso rape case and human trafficking, Pamela Mabini, was shot dead in the driveway of a home in Kabega. She was also shot by unknown gunmen in May 2018 after receiving threatening messages. Now, if this wasn't a clear indication that Mrs. Mabini or Ms. Mabini needed the protection, where was SOCA then? Wasn't their role to actually protect? Because part of their role is the creation of an integrated case management system that increases the conviction rates of perpetrators and gender-based violence, and to create a safe space for victims. So where wasn't, this is another failure on the side of the NPA to actually protect a key whistleblower in this particular matter. Then also Advocate Batoyi says she's going to appeal the outcome of the matter, but they've also going to deport Omotoso. We've seen with another perpetrator of GBVF, Shepherd Bushiri, where we are struggling to extradite a criminal to stand trial. So we're going to deport Omotoso and then appeal the matter. And when he's found guilty this time around, we're going to struggle to extradite him. And in the case of Shepherd Bushiri, there's also charges of rape against him. And then, Chairperson, the other one is even more alarming, is, you know, these are failing cases, but then they also fail to respond and prosecute cases. There's no prosecution around Marikana, the Zondo Commission cases, the Life Esidimeni cases. It seems as if cases that involves the Black working class are not considered important. Last year, on the 14th of October, I laid a complaint against someone who participated in the genocide in apartheid Israel. Firstly, when going to hand deliver the complaint, I get assaulted by thugs that they employ as security at the NPA here in the Western Cape. There are other cases or reports on people participating in the genocide in Israel as part of the Israeli Defense Force. And what is very clear, it cannot be that there's insufficient evidence, because none of these people, in terms of the Foreign Military Assistance Act, have permission to go and participate in the genocide in Palestine. In fact, South Africa has got a duty to do everything in its power to prevent a genocide. But yet here in South Africa, these cases are not responded to. These reports are just put one side. There are South African Zionist organizations and the chief rabbi encouraging participation in this genocide, and nothing gets done about it because the NPA won't prosecute people who are guilty of contravening the Foreign Military Assistance Act. Why is the NPA turning a blind eye to these perpetrators of genocide? Why are they not prosecuting? Why can a chief rabbi go and encourage participation in the genocide? Why can our members of parliament go and whitewash that genocide over there? Because the NPA is weak, very weak. You can't even prosecute cases where there's blatant criminality. I'm not surprised that you fail at a successful prosecution of the Omotoso. The NPA is incompetent. And it rots at the head. And something needs to be done, and it needs to be done very quickly, because we are degenerating as a state. So what is going to be done? Number one, about protecting whistleblowers like Pamela Mabini in the future. How are you going to address the fact that you want to deport Omotoso, but you still want to appeal the outcome of the matter? And how are you going to deal with these reports of South Africans participating in the Israeli Defense Force? Part of the genocide, yet you refuse to prosecute people who are participating in that genocide. Thank you very much, Chairperson.
Thank you very much, Honorable Paulson. Honorable Musha.
Thank you, Mr. Chairperson.
Chairperson, after me is Honorable. After Honorable Paulson is myself.
No. Honorable
And
Mshala.
you say you're going to follow. You said you're not allowing. No, but you can't do that to us now.
No, you're out of order.
Because we can see your interest is not to see us presenting in this case.
No. There's
You
no
can't
one.
do that.
Honorable
Because
Mshala.
Chairperson, stop being out of order and stop treating the EFF the manner in which you are treating us. You come with decisions that are not even, you're not supposed to be taking, because your intention is to remove me.
No, it means, Honorable Mshala, you were not listening.
Your intention is to remove me.
No, Honorable Mshala, please, man.
You said you are following the sequence. The sequence of Nazir Paulson is myself.
There's no such a thing. I'm the one who was pointing out people
Please
here.
tell me what is the sequence? What is the order?
What sequence? What order?
When you were
you're coming
up our
after
name.
Honorable Mashwe. Don't do what you're doing. It's unnecessary. You're diverting us on serious things here. Honorable Mashwe, please.
No, Chairperson, you can't do that. You are very out of order.
Please proceed.
We are noticing what you are doing.
No. It's wrong what you're doing. You're diverting us.
Wrong. You are wrong.
No, I'm telling you, I'm the one who
allow us to speak.
No, man. Honorable Mshala, please. Honorable Mashwe, please proceed.
But please assist us in terms of when am I speaking? Because it was Honorable Paulson.
Honorable Mshala, when I pointed people out, I named them by name. I said,
please,
Honorable Honorable Swart, Honorable Breitenbach, Honorable Nomvalo, Honorable Matafa,
Yes.
Honorable Klopa,
Yes.
Honorable Totets, Honorable Doena, Honorable Mutaung, Honorable Mhlongo, Honorable Paulsen, Honorable Moshe, Honorable Mshala, Advocate Sally. That's what I said. It means you are not
But
listening.
that the sequence was
I
not like
said it
that.
louder. No, I said it louder. It means you're
But
not
it's
listening.
fine. We'll allow you the manner in which you
No,
want
no.
it.
Honorable
It's
Shala,
okay. Thank
don't
you.
do this. Don't do this, please.
No, it's you who's out of order, Chairperson. You can't do us. Just change along the way. What is the problem with you? Why you don't want to allow us to speak?
Please proceed. Honorable Shala, don't do this thing you're doing, please.
Honorable Chairperson.
You're very out of order and we're not going to allow that.
Honorable
Proceed,
Chairperson, thank you for the opportunity to contribute and to raise questions to the NPA. I can confirm that when you mentioned my name, it was after Honorable Paulson. That I can confirm. And thank you for sticking to that. Advocate Batohi, among others, said Omotoso is facing deportation. Now, this came as a surprise to me because we were told in one of the news that Omotoso is going to face retrial. He will not be deported. Now, we are not sure what is what. So I should ask the NPA and the NDPP whether they have made a request to the Department of Home Affairs or to the Minister of Home Affairs not to deport Omotoso until the conclusion of a retrial, or have you approached the court of law to ensure that he is not deported before a retrial has taken place? We know that it is difficult to deport a person and bring him back when there are cases against them. My predecessor was correct in what he said about other cases of people that were deported. So if a formal request has not been made, I want to appeal to the NPA to make a request to meet with the Department of Home Affairs or with the minister to ensure that he is not deported until a retrial has taken place, and hopingly until he is found guilty, as a majority of South Africans believe who have been following the cases. And my second question, Advocate Batohi again said that she is willing to meet the victims of these heinous crimes that have taken against them. She is willing to meet them. My question to her is whether it is just a willingness or is it a decision? I think she must come to a place where she decides, I'm going to meet them. And it would be good for her to tell us, meet them to say what to them? To say what? To sympathize, to reassure them that justice will be done, but I think it would be a good thing for her to meet with them. In the press statement I made on the 3rd of April, after the acquittal of Omotoso and his co-accused, among others, I said the NPA needs to apologize to the public because we are all devastated, we are all let down as a country, and they needed to say something like an apology. If I missed it, I want to be reassured that an apology has come out and be told when it did come from the NPA. And if it did not, it would be a good thing for Advocate Batohi to make that apology when she finally gets an opportunity to meet with the victims. And I hope that it will not be too late, that she will meet soon with them. And my third question, Judge Kuman criticized the prosecution team for poor cross-examination. Now, as this was a high-profile case, I am surprised, and many people are surprised, that juniors, inexperienced people were used in the prosecution. I want to know why the NPA did not assign to this case, or Omotoso case, senior and experienced prosecutors to ensure that he and his co-accused are found guilty for what they have done. It is embarrassing that after about 32 cases, well, lastly it was 32 cases, started with a double that number, that they were reduced until they were 32, 31, and all of them, they were found guilty because of poor cross-examination. Where were the seniors? And as the trial continued and people could hear and see that the prosecutors were definitely fumbling, why was there nothing done? Because members of the NPA were watching, hopingly the procedures they were watching, and when their team members were not doing well, I think a supervisor should have stepped in. There were enough indications and red lights that they were not going to win the case, but nothing was done, as if that was the outcome they wanted, that Omotoso should be acquitted. So as there will be a retrial, hopefully there will be a retrial, we want to ensure that the NPA, and I want to appeal to Advocate Batohi, get the best of your best, regardless of whether they come from Messina, Limpopo, Gauteng, or where, but get the best of the best among your team to deal with this case, to ensure that that man pays for the crimes he has committed against innocent women who were in church. And my last question, has the NPA or NDPP made an appeal, made an application to bar Omotoso from carrying on with church meetings where he will get opportunities to get close to ladies in his church that he sexually abused and raped them? There has to be an appeal. Other women have to be protected. As far as I am concerned, that man is dangerous. He should not be allowed to be around women. He should not, particularly in a church environment. So if an application is not made, then the people are going to be harmed again. Innocent people are going to be harmed. And I must salute the mayor of East London. The mayor of East London municipality, who refused him permission. He applied to have meetings, church meetings around East London. He refused. He did the right thing. And I wish that the NPA would take his example to make sure that this dangerous man does not come close to women in church again. If he wants women, must go somewhere else. But in church, women and everybody else must be safe. Thank you, Mr. Chairman.
Thank you, Mfundisi. Honorable Mhlala.
No, thanks so much, Chairperson. Let me shoot straight to the issues of the day. My name is Honorable Rebecca Moshala, a member of Parliament deployed by the Economic Freedom Fighters. The only organization that consistently stands with the dejected and forgotten masses of our people, especially when the state, which is constitutionally bound to protect them, instead chooses to harm them. Chairperson, we want to put on record that the justice system in this country has collapsed. The South African Police Services, the NPA, and the judiciary. There are a lot of issues happening in this country, and we no longer have confidence in the prosecution or the entire justice system. This system has collapsed, Chairperson. I'm therefore not going to be single-sided in approaching these issues. I'm going to look at the overall context of what happened, because isolating any one part would not serve justice. Yes, the NPA has failed, dismally so in this case, but the court also had a duty to assist the process. We will not treat this matter, I think, in isolation, because doing so will ignore the collapse we are seeing across the entire, criminal justice system. Chairperson, as the Economic Freedom Fighters, based on our thorough observation on this case, the EFF is extremely concerned about the manner in which this trial was handled by both the judiciary and the National Prosecuting Authority. We believe both institutions failed the victims of gender-based violence, more especially this one in Omotoso case. Chairperson, under Advocate Shamila Badoy leadership, the NPA has repeatedly failed to demonstrate competence and integrity in handling high-profile prosecution, the Singiso Magaka matter, the Senziwa Meiwa matter, and many more. In this case, the NPA was very disorganized, unethical, and unfit for the scale of the matter, as clearly recorded in the attached NPA report and also in the judgment itself. So I want to start by showing the key failures. The lead prosecutor, Advocate Ntelo, was found to have withheld critical contradictions in witness statement and even suggested coaching witnesses to commit perjury. The judge found his conduct grossly incompetent and dishonest, yet the National Director of Public Prosecution failed to take decisive preemptive action to protect the credibility of the trial. So the entire prosecutorial team, under the supervision of the National Director of Public Prosecution, Advocate Badoy, collapsed under pressure in one of the most sensitive GBV cases in this country. Chairperson, we are forced to discuss prosecutorial incompetence in a case that carried the cries of over 11 survivors of sexual violence. That alone should compel this committee to demand Advocate Badoy's resignation. He has failed the justice system. Another point, Chairperson, I want to bring, Judge Imas Kuman has served in the High Court since the year 2000. Her experience spans more than 25 years, and it's not our view that she lacks understanding of her judicial duties. However, her judgment in this case raises deeply troubling concerns that must be addressed. I'm going to touch now the observation that we have observed in this case. The judge did not adequately engage with the accused version. We note that the court failed to critically engage with the version of accused number one, Omotoso. This is concerning, particularly given the detailed examination of the 11 complainants' testimonies. When you look at the presentation of NPA, paragraph 3.6, they say that the accused denied all the allegations under cross-examination. They further state that the cross-examination was extremely poor. There was no proper testing of complainant's version, nor of the accused version. That is paragraph 59 of the judgment. A person, despite his blanket denial, the accused was not pressed on specific factual contradictions. These omissions is a stark considering the complainants consistently described being summoned to Omotoso's room, massaging his feet, being assaulted, and then forced to clean themselves. This pattern should have prompted deeper scrutiny. It did not by the judge. Observation number 2 that we have observed, the court ignored common cause facts. Certain facts, such as the practice of foot massages in a private bedroom, were not disputed, yet not meaningfully interrogated. It is common cause that the complainants massage his feet according to the complaints. It is generally during those appointments where he sexually it is alleged that he sexually assaulted them or raped them. It is in judgment, paragraph 8. So, Chairperson, why would a religious leader repeatedly call young girls into his private quarters for this task? The court failed to confront this question, creating a judicial blind spot. Observation number 3, Chairperson, the court did not explain why 11 complainants would fabricate similar allegations. The judge failed to provide any rationale for why so many women, unrelated and from different contexts, would concoct coordinated lies. While not in a single paragraph, the judgment offers no analysis of this obvious question. Your body parts will be scattered all over, and dogs will drink your blood in the street. That is in the judgment, paragraph 20. So, Chairperson, in our analysis and our observations, this threat shows spiritual and psychological domination, not fabrication. The absence of motive for 11 people to lie should have raised judicial concern. So we go to observation 4, Chairperson. The judge ignored relevant legal precedents. The judgment does not reference the Supreme Court of Appeals ruling in the State versus Mafalajiso 2005, despite clear contradiction between complainant's earlier statement and court testimony. A legal precedent was never cited or applied in this judgment, yet it provides the proper method for handling inconsistencies, a central issue in this case. Chair, in terms of observation 5, the court used the prosecution incompetence as an excuse to disregard evidence. The judgment most critical turning point lies in paragraph 59. The primary factor was the lack of cross-examination by the state prosecutor. It shows that the court leaned too heavily on prosecutorial failure rather than using its own powers under Section 186 of the Criminal Procedure Act, which empowers judges to call additional evidence where justice requires it. The function of the court, Chairperson, is not that of being a neutral umpire. You must try to assist the court. So in that regard, I've got a question to the NPA. Did the NPA raise concern with the judge about invoking Section 186 to call necessary witnesses? Did the NPA consider applying for the court to step in where the trial was obviously going? When the trial was obviously going, of course, did the NPA, under the leadership of Shamila Batoyi, advocate, try to intervene in that regard? We must not be told when things have collapsed and they see now that they are in trouble, they come here and say that we are intervening when everything has actually collapsed. Chairperson, another observation is the issue, that one I think I've already touched on it, of Advocate Ndela, who was grossly incompetent and very dishonest in that regard. That shows the failure of NPA in such a very high-profile case in South Africa, where the justice system was supposed to prove itself that it is capable in handling matters such as these ones. Another observation, the National Prosecuting Authority failed to prevent or correct these failures, despite being aware of red flags. The NPA reinstated Advocate Ndela after removing him following just one witness. Why did the leadership in the Eastern Cape reinstate Ndela despite internal warnings and known misconduct? Was the NPA aware that such a move would compromise the integrity of the prosecution? This investigation started in August 2024 as per the presentation. And there's a view that the expanded team will finalize the investigation by mid-June 2025. So, Chair, the NPA began investigating only after the case have collapsed, actually, confirming institutional delay and negligence. Chair, another observation in this matter that we want to also raise is the issue of the NPA may be undercapacitated in handling rape cases. With over 40,000 rape cases reported annually in South Africa, many require specialized prosecution, something clearly lacking, I think, in this case. So what plans exist to capacitate, train, and deploy prosecutors equipped to handle GBV-related matters with the sensitivity and professionalism they may demand? So, Chairperson, we want to give you an ultimatum of what must happen. We are requesting the Portfolio Committee take a decision and request Advocate Shamila Batoyi to step down. And if she refuses to step down, Parliament must initiate her urgent removal, because not so, the collapse of justice system for GBV cases will be endorsing them, also be endorsing the corruption of prosecutorial ethics and erosion of public faith in the judiciary. The other matter that I want to raise before the Portfolio Committee is the matter of Tswetswe. I formally would like to raise concern regarding the handling of the case of Tswetswe at Matatiele SAPS, which has reportedly been referred to the senior public prosecutor according to the information that we got from her mother. But according to the mother, she's very distressed about the lack of communication, transparency, and accountability from the side of the police. And also, I won't say the prosecutorial team, because the information she got is that the case is being referred to the prosecution to take a decision if they are prosecuting, they are continuing with the prosecution. So we are requesting that this case be given the attention it deserves. We don't want to see this case going into the same routes as what we see with Omotoso case. So let's make sure that we attend to the case as soon as possible. According to the mother as well, she received clothes that she was told they are going for DNA testing, but she did not get information of what is happening with those clothes. What is the results, the outcome of forensic testing, particularly on the clothes that returned to the family. So we are also requesting that a direct liaison officer or victim support officer to be assigned to the family to ensure consistent and human communication. Lastly, Chairperson, is the matter of Pretorius. Chairperson and honorable members, what the NPA is doing is not justice, it's a manipulation. The appointment of Advocate Pretorius, who led evidence during the Zondo Commission, to now advise on prosecutions based on that same evidence is unethical and intellectually insulting. This is a clear case of the NPA playing both referee and player, undermining public trust, internal capacity, and basic fairness. Even worse, Chairperson, the NPA lobbied for him on national television before any formal process was announced. That is not accountability, Chairperson. It is arrogance, actually, on the side of the NPA. So, on what legal and procedural basis was advocate Pretorius appointed, and was the position publicly advertised. How does the NPA justify appointing someone to advise on prosecution based on evidence he helped lead without acknowledging the clear conflict of interest? Chairperson, we are not going to allow that. As the EFF, we are against that thing. It must not ever happen. We are not going to allow people run the NPA as if it's their own personal firm of law. We are not going to allow that. So advocate Pretorius cannot lead evidence and at the same time come now and advise in terms of how to prosecute those people that they've been mentioned to be implicated in the state capture cases. So we need to look into that, and we are not agreeing with it. Lastly, Chairperson, who authorized the NPA's public lobbying for this appointment on national TV, and where were public funds used to promote this decision? Thanks, Chairperson. I'm done. Thank you.
Advocate Sally.
Thank you, Honorable Chair. Thank you, Chair. Good morning. Assalamu alaikum, honorable members, NDPP, and all on platform. As Al-Jamaa, we are disappointed is a mild word. We are disgusted, embarrassed at what has transpired in this Omotoso case. We duly note the duties of the NPA and structures in place and the work being done under very difficult circumstances. We are aware, none more than those who has worked in the institute of the NPA, of the duties, responsibilities, and work done. The details provided by the NPA, it is clear it is to appease and soften the blow of repercussions due to the failures in the NPA that is currently being exposed. 77% conviction rate in prosecution does not speak to the matters withdrawn in the NPA and the reality of no reporting due to many having lost faith in the justice system and in the NPA. And I know there are entities who despises the fact when we actually raise the fact that justice is failing us and the wheels of justice are currently falling off, and part of the responsibility is because of the NPA. 8 years, Honorable Chair, to complete a matter. We require a complete breakdown on where those failures occurred. And what we will find is that many cases, and there are many delays in the justice system and in the NPA that are failing our people of this country. The Omotoso case exposes the failures in the NPA, but it also exposes the lack of oversight and accountability. The lack of training and ethics and discipline is highlighted of those in prosecution, and we wonder what disciplinary steps will be taken. A serious matter where alarm bells has been raised surrounding the prosecutions in the matter has been blatantly ignored. The NPA today, we query the failure of the CA to put in checks, balances, and accountability. Oversight was seriously lacking in this matter and needs to be responded to. What oversight was placed whilst the investigation of this? Where was the oversight of the seniors, fully knowing that this matter was gathering a lot of media attention and it's actually a very serious matter? Then I would like to know what is the years of relevant experience of the teams of prosecution that was considered and assigned to this particular matter. And the key word here, Honorable Chair, is the word relevant experience. The lack of leading evidence as is highlighted in the judgment, and it is absolutely shocking. It's actually appalling. Had this matter not had media attention, it makes one wonder how many cases are falling through the cracks of the NPA due to the concerns of lack of ethics and the ability of the prosecutors. Why must a matter have media attention before it comes to this particular portfolio? How many victims are we failing? We cannot ignore the trauma of the victims by people that is alleged to be the people's lawyers who has failed them. what systems is being put in place to assist the victims, and how the victims how is this victims going to be compensated? We talked about secondary degree trauma. I think that the trauma that has been suffered by these victims are far more. The NPA should be held accountable for their failures. We now only we note that there is senior counsel and senior individuals assigned to this matters, which is another failure on the side of the NPA. These senior individuals had to be appointed at a long time ago at the beginning of this matter to investigate, prosecute without fear and favor or prejudice. It is heartbreaking today that an institution that's supposed to be one of the prides of our nation, because the authority that they hold and the power that they hold is failing the victims of our country and prejudicing the victims of our country. We welcome the investigation being conducted, but demand that this investigation be expedited. We are shocked about the lack of sensitivity on WhatsApp groups, where complainants are placed onto one WhatsApp group. And Honorable Chair, it was mentioned before, but we need to know what was the content and what was the purpose and discussion on these groups, because it will be highly concerning that complainants are discussing the matters in one WhatsApp group, and these same individuals would end up having to testify on these matters, and it can impact on what is being said in court. We note all the efforts being made now by the NPA to rectify their wrongs, and we need to note that while an appeal is primarily concerned with legal questions, it's not entirely based on law, not facts. Appeals can challenge the application of the law, the facts of a case, or the factual findings themselves, if it can be shown that the trial court made errors or misapplied the law. I don't want to go into too much of the merits, because we know that that will now be under investigation, and it will also be brought before the appeal court. Just makes me wonder, where was all this efforts? And ultimately, once again, these other victims, which is the taxpayers, who is going to ultimately also be impacted by monies having to be paid because of prosecution failure. The accused Omotoso will now be deported, and the victims will be denied justice, Honorable Chair, and that is the reality. And the NPA will ultimately have to bear the consciousness of the fact that this person is a threat to society globally. Further, Honorable Chair, I want to place on record and concur with Honorable Paulser, is the failure of the NPA to investigate and prosecute serious crimes and crimes committed against humanity. Not one South African has the right to be fighting in the IDF, but to date, despite cases laid at the NPA has failed to investigate and prosecute the charges against foreign mercenaries. Do we lack the skills in prosecution to investigate and prosecute these type of matters? That is another question, and maybe that is why Advocate Shamila Batoy is probably dodging the bullet on that particular matter. The lack of communication and evading of these matters also speaks to how prosecution is evading matters within our own country. Do we lack the resources? Do we lack the relevant skills and qualifications in the NPA? And also, another factor of concern is the arrogance that has been displayed for a very long time in the National Prosecuting Authority and in the NDPP's office. So, Honorable Chair, one of the things that is very important here is that the investigation be expedited, and that we are all answerable to South Africa with regard to not just this matter. This matter is being highlighted, but Honorable Chair, I can promise you there are many of a similar matter that is before courts and not before courts, where the NPA and the NDPP's office is failing South Africa. And I will too duly note that Shamila Batoy needs to be removed from her position. And I thank you, Honorable Chair.
Honorable Zotezi.
Yeah.
Honorable Zotezi.
Yeah, I think if my hand's still up, might have been the legacy hand. I've been covered by honorable members on other issues that I would have wanted to deposit. Thank you.
Thank you very much, Honorable Zodetsi. NTPP, I've got some
Chair,
questions.
sorry, you might have not seen my hand. I came in very last in the queue. Very briefly, please.
Oh, no, you were not there, Honorable Nyamanye. You joined late.
Yes, I agree.
You were not there. Don't say I didn't see your hand. You were not there.
Oh, okay.
Can we do this, Honorable Manye?
Sure.
I'm going to pose questions. We allow them to reply. If your issues are not covered, we allow you to ask them. Please.
Mine was going to take just 1 minute, Chair, please.
Okay, let's give you a chance. Fine.
Thank you. So that when the chair has spoken, we don't speak after the chair. Chair, mine is a brief one. Under a quick theme of the fish rots from the head. And just a quick summary, Chair. I mean, we sitting here, you know, as political parties in Parliament, we differ on many things. But on this one, we seem to be all united. Here's an executive summary, very briefly. The NPA has failed in the extradition process of the Guptas. They were using defective warrants and all of that, and the court has ruled on this. This is not me saying this. The NPA has failed in even doing a proper risk assessment on Bushiri to check if he's a flight risk or not. We're sitting now with a fugitive in Malawi. The NPA has failed to conclude on the Makaka case, has failed to conclude on the Meiwa case. I mean, a very glaring thing here, where even some of the people that were at the scene of crime, as we speak today, 10 years later, some of them have still not even appeared before the court. They have bungled up a whole lot of cases there. Kokomachela case, we're still waiting on the AKA case. We're still waiting to hear what Advocate Batoa is going to say about the fake it till you make it, a charade that people are doing there. Now she has bungled the Omotoso case. And on Wednesday this week, the MK party on the member statement raised the issue of Advocate Pretorius. This is the person that was leading in the Zondo Commission. The issue for us is that noting that the evidence led in the Zondo Commission, which was a concoction of hearsay and everything else, and which actually does not meet the criminal justice standard for prosecution. Now, all of a sudden, Advocate Pretorius is now going to advise how to turn evidence, which is otherwise not prosecute material, which is not within the criminal justice dictates. Somehow he's going to find a way now to advise how that is going to be done and all of that. So I don't want to waste time here. I just want to conclude by saying for us as the MK party, we want to just put on record that if by end of this meeting that Advocate Batoa does not voluntarily submit her resignation, we want to confirm in this meeting that as we close this meeting today, we would have approached the appointing authorities to start the process to remove Advocate Batoa. I think enough is enough. Thank you, Chair.
Thank you. Okay, I'm going to pose a number of questions as well, but my questions are going to be in the context of Section 22, subsection 1 of the NPA Act, which actually gives an authority to the NDPP as a head of prosecution to exercise all powers and the performance of all the duties and functions conferred, imposed on or assigned to any member of prosecuting authority by the Constitution. And I'm going to ask some of the questions in the context NDPP of Section 22, subsection 4D, which actually gives upon you a responsibility and a power to assist the directors and prosecutors in achieving the effective and fair administration of criminal justice. But I just want to check maybe, please provide a quick answer here, because everything else is dependent to what would be the answer. NDPP, have you ever made an effort to meet with the DPP of the Eastern Cape together with the prosecution team in the Omotoso case? NDPP? Members, can you hear me?
We can hear you.
You are
Oh,
loud and
sorry.
clear, Chair.
Sorry, my apologies.
NDPP? Okay,
Yes.
can you just take that one?
Sure. In this particular case, I did not meet with the DPP or the team, but of course, had the DPP requested or brought certain things to my attention, then I could have decided on what a national director should do. But in this particular case, the DPP was dealing with the late Advocate Rodney de Kock, and regrettably, no red flags were brought to my attention, so that did not happen.
Okay. No, I'm asking you specifically, NDPP, because the National Prosecuting Authority Act refers to you, the national director. It does refer to deputy national public directors of public prosecution. But these two sections I'm talking about refers to you as the head of the prosecution authority.
Yes, and the NDPP delegates certain functions to the deputies.
We'll come to that.
Sure.
Now, there is a need coerced by circumstances for a change of the prosecution team. Now, the DPP presides over the process of ensuring that the prosecution team is changed because there are coercing circumstances that warrant that the prosecution team must change. But still, you saw no need. You're going to come back on all the issues I'm going to raise when you come for responses. But still, you do not see a need for you to go down in adherence of these provisions in the NPA Act and assist them, understand their challenges, so that you give them the necessary support and so that they have the necessary capacity to proceed with the case. DPP, maybe this one will be very relevant to you. Part of what is being said is that part of the statements the complainants have made was that they have made numerous attempts to the SAPS to report sexual abuses, but they were turned back by SAPS that they must go back and resolve these matters in that particular church where they are actually abused. So have you been able to help the victims in that regard so that they report where they are supposed to report that kind of the conduct from members of the SAPS? Honorable Mhlongo raises a very, very serious matter here of advocating Ntelwa. Whether he is still in the employ of the NPA, are we paying the remuneration and benefits to him? Is he suspended or not? If not, let me go to the if not. If not, what is it that you are actually waiting for? What kind of evidence are you looking at? If even a court judgment, unless you are actually doubting the court judgment itself, because I think even the factors of law that you are appealing on have nothing to do with what the judge says about the conduct of Advocate Ntelwa. Now, the judgment goes to an extent of saying the lead prosecutor subordinate complainants in committing perjury. Now, let's go to a simple explanation of subordinate. honorable members. Subordinate in terms of the definition in the Oxford Dictionary, the symbol says bribed or induced to commit perjury. So if you have not acted against the then lead prosecutor, what is it and what kind of evidence that you are waiting for you to act and be able to enhance consequence management in this matter? Look, this matter does require serious consequence management. And I think it is indicated in the report that Advocate Berimadolo would have reported this matter in 2024 in the labor unit in the NPA. I'm not sure if the statement you issued does not bring any progress report in respect of what Advocate Madolo reported in 2024. Was Advocate Madolo reported in 2024, while in May 2025, the statement just says the NPA is going to proceed with the investigation that was started by the labor unit maybe in 2024. So maybe also as part of explaining the consequence management that we are going to undergo, explain or rather update the committee and the public on the issue of the progress report since the reporting of Advocate Berimadolo in 2024. Look, there are a lot of issues that the judgment itself is outlining to us, which include that the consultation by the lead prosecutors, soliciting statements from the complainants, and the statements that were solicited by SAPS were contradictory. And if this is the case, NTPP, do you not think that, have you taken time in adherence of Section 22 to go attend and get closer to the team or any team that is handling a high-profile matter? These some of the matters that are raised in the judgment would have been prevented before they happened. The issue of the irregularities that are pointed out in the judgment itself, had you gotten closer to the team, including the DPP and the prosecution team specifically for this particular matter, do you not think that these matters would have been avoided had you been closely monitoring this situation, not only this situation, other situations that are involving high-profile case matters? Won't count them. The complainants, NTPP, themselves made an indication to you that they no longer feel safe and trust the team that you have bestowed them to lead their complaint in court. And they've indicated that through writing a letter to you. And still, you have not seen a need for you to get closer to the situation. In adherence of Section 22, subsection 1, Section 22, subsection 4D. There's a letter written to you. It's an unusual process. You have complainants that are in court. The DPP sends a team that he trusts to deal with the trial. But in the course of the trial, the complainants, because of their dissatisfaction, so write to you personally as the National Director of Public Prosecutions to attend to a specific matter they are not happy about, and still you did not see a need to get closer to the team that is handling the matter. And it is my belief that had you gotten closer to the team, working closely with the DPP, you would have easily seen that there are some of the witness statements that were concealed by Advocate Ndelwa. You would have picked up that already Advocate Ndelwa is acting unethically by going to an extent of opening a WhatsApp group between him and the complainants. And part of makes it more suspicious is the fact that those messages that were communicated in that WhatsApp group are now deleted. Look, it is my, the judgment is actually scathing. It goes to an extent to say, the judge says actually, Mr. Ndelwa doesn't understand the definition of rape. That's what the judge says there. And in my view, NTPP, had you been closer to that situation, you would have picked up the weaknesses of the team that is tasked to attend to that very critical trial. 14 years of experience, that's what the judge is saying, with a person who's struggling to understand the definition of rape. So my view, I'm trying to display to you, NTPP, that you have failed as the NTPP to get closer to the situation. Had you been able to get closer to the situation in accordance to this act? And I hope you won't pass the ball to another person, because the act refers to you as the NTPP. I'm sure you'd have picked up some of these weaknesses and be able to reinforce or change the team working with the DPP. There is no doubt that at this particular point, we all agree that we failed those victims. And we are given a second opportunity to recover the lost ground. And with the hope that we won't mess up this particular issue. And it is in my view that had you been in adherence of what is said in the act, you would have picked out that the team does not have a necessary capacity, such to an extent that they were even unable to do an adequate cross-examination. And my view is that, as the member of parliament, is that had you been closer to the situation, as the act directs you to, you would have picked up part of these weaknesses, and some of them would have been avoided. In 2023, a letter is written to Advocate decorum. It's written by the DPP, reporting about this thing. In 2023, NTPP. And it is my belief that in such matters, the Deputy National Directors are unable to act without consulting you. 2023, the DPP in the Eastern Cape writes to the late Advocate Rodney Tikok complaining about the misconduct in this trial. The judgment is handed down in 2025, April, but still there is no action that had been taken to avert this situation. It is in my view that by failing to take drastic actions to attend to what the DPP was raising, would have at least averted some of the issues that had been raised by the court against us. So, and I'm not sure, maybe take us through NTPP. Why is it still the DPP of the Eastern Cape that is appealing this judgment? Why are you not taking the matter of the state versus Omotoso criminal trial to your hands? Why is it not sitting on your table so that you yourself, in accordance to this act that governs you, you lead the most capable team to go and argue evidence in the Supreme Court of Appeal? Why is it still residing in the Eastern Cape? Maybe let's pass the judgment now. We have got a Criminal Procedure Act that limits you in terms of the circumstances where you can appeal an acquittal. You are here in Parliament now. What do you think Parliament must do in assisting the Prosecuting Authority in trying to strengthen their powers in terms of the appeal on acquittal issues? Well, in the review of the Criminal Procedure Act, how do you think we must be able to assist the prosecuting authority in that regard? The defense, honorable members, Advocate Madolo, the defense immediately after the state closes its case simply runs for a Section 174 application. That, in my view, was indicative that we have a problem. In my view, awakened your conscience to get closer to the situation as the trial proceeded. We say we are proceeding with an appeal against the judgment of Judge Skuman, but say we're going to file our papers within reasonable time. And I've got a problem with the wording. And I'm sure the wording, Advocate Madolo, was chosen very carefully. This matter is a matter of a serious societal interest. There is no doubt amongst all of us here that this matter must be expedited so that we're able to see justice being done. So saying within a reasonable time, we don't know what is reasonable in your own understanding. So if you can tell us that in terms of your turnaround strategy on this matter, what do you mean when you say reasonable time? Because as things stand now, as we are presiding over some of the experiencing some of the delays and the problems, it does look like even 5 years can be reasonable in the NPA. So what is this reasonable time? Tell us. In terms of your strategy and your plan, you expect that at least by this particular time, you would have filed the papers in the Supreme Court of Appeal. DG, I'm not quite sure if you are aware or you have been mandated by the minister to brief us on the Section 33 report that she has requested from the NTPP. What did the department pick up? How did the department try to prevail in this situation? And how far now are we, DG, with the review of the Criminal Procedure Act? And one thing, NTPP, that I'm going to commend the NPA on, and it's one thing, trust me, it's one, is the communication. It has drastically improved. You are able to keep communities and the people of South Africa abreast on what the prosecution is doing, where it is finding challenges, and where it is winning some of the cases. And in that, I commend you, NPA. You are doing very well in that. One question to Advocate Madolo. Advocate Madolo, what is your impression about Advocate Ndelwa? Do you think that he deliberately sabotaged the trial against the state and against the complainants? What impression do you have about his conduct, his theatrics, his incompetence, his uselessness, and everything else? Look,
should I respond?
No, you'll come later, Advocate Madolo.
Oh, okay.
At least you have got a better video now.
Thank you.
Look, there's no doubt. There's no doubt. I think another member was asking about how do you think this will impact the criminal justice system? And I can answer, honorable member, I just forgot which one was. The impact of this mess is people of South Africa losing confidence in the South African criminal justice system. And by that, taking the law into their hands. And by that, we'll be required to go to the communities and talk to those people. And at the time when we go there, they will no longer be listening to us. Nor will they be listening to any authority of the state. And the country will become lawless. And that's the situation we must always fight, that this country must not become lawless. So thank you very much, members. Let's allow now the team. We'll start with the NTPP. We'll take the DPP. We'll take Advocate Boni. Then we'll take the DG or Advocate Pile.
Thank you, Honorable Chair. There are one or two other NPA colleagues that will need to respond with regard to other issues relating to the matters in respect of disciplinary matters, etc. But before I hand over to colleagues to deal with questions, and then I'll come back at the end, and to just ask that the DG also deal with the question relating to whistleblower protection. So, Chair, yeah, no, not surprisingly, we have come under serious criticism and attack in this session today. It's understandable because of what has happened. I expected that, you know, there will be very hard questions, and they have been. I just want to reiterate one or two things. And Chair, maybe to clarify on your last question so that when we answer them, we are on the same page. Just to understand, you know, you asked a lot of questions about my intervention and that things could have been different had I intervened. I want to ask for clarification. Is it the Chair's understanding that Advocate Ntelwa is one of the prosecutors still in this matter and in fact prosecuted the matter until the end?
No, I know they had been changed.
Okay,
that's
all
why
right,
I
that's
was
fine.
asking. That's why I even said my first question was that the first team was changed and a second team was put forced by circumstances. And my view is that you should have started getting closer to the situation.
Even with the second team?
Yes.
Okay, I'll deal with that. So, Chair, firstly, let me make a few comments, responses to some of the comments that have been made. You know, just to say that we framed our presentation in this way that is dealing very specifically, and we were not aware that the expectation was that we will go back in time. We understood it to be, what are we doing to address the impact and the consequences of Omotoso decision? And that is how it was framed. But what we did is we dealt with all of those issues, the 3 key interventions. But the reason why we also included some of a fraction, a small, minute fraction of the really good work that is being done by prosecutors across the country, who I would ask not to be demotivated by this session. The reason why we included this, it wasn't to get any applause for it. It certainly wasn't, to sugarcoat the devastating impact of the Omotoso decision. That was not the intention. The intention was really, we understand that the Omotoso decision has dented confidence in the criminal justice system. And the reason why we thought it's important that we deal with these issues is that many of the honorable members raised the fact that people lose confidence in the system. Victims may not come forward. And the reason why we included all of this is really to appeal to victims. Don't throw the baby out with the bathwater. This is a very important decision. It has had a devastating impact. And more than that, the victims, of course, feel it more than anyone. As the NPA, we feel it because of the impact on the institution. And so because of that, we wanted victims to know, which is what I said in my opening address. We are saying this because understand this is one case, but a very important case. But please don't lose faith in the system, because there are so many good things that are happening in the system. And that if you happen to be a victim in the future, please don't be discouraged by this one decision. Know that you will get the necessary. Firstly, know that we are ensuring accountability, and we are, with regard to the 3 interventions that I mentioned, but also know that you will get world-class service, which victims across the country are getting in many Tutuzela care centers, but also there's many support services in places where there are no TCC. So I really want to urge that the idea was not to sugarcoat. This has been a devastating decision, but it's really to say to victims out there, please don't underreport. You do nothing wrong. Come forward and report these matters, because you will get the services that you need, the support that you need, whether it's legal, psychosocial. You will get these services to make sure that at the end of the day, justice prevails. And that was the only reason why we did this. It is not to receive any applause for it, but to really give confidence to the victims that don't lose faith in the system because of this one case. There's a lot of good work and hardworking prosecutors that will support you and help you get through to this process to become a survivor. So that was the only reason why we did that. And we still think it was important to have done it. We would appreciate perhaps if the portfolio committee wants us to come and do a separate presentation on all of those things, which it was the tip of the iceberg today. We are happy to do that, to build more confidence in the system, which has been badly dented. So I think I'm going to, at this point, call on perhaps Mzanyati, can I call on you? Should we go to Barry Madolo first to deal with? Perhaps Barry, I think it would be best if you deal with some of the matters, and then we'll look at what still needs to be covered. Can I hand over to you, Mr. Madolo?
Good afternoon once again, Honorable Chair and Honorable Members, NTPP. I'm trying to check, where to start, but let me go on by start by saying this. I got on board, on this matter, and I'm responsible for the last team that dealt with the Omotoso matter. And in terms of their experience, they are seasoned prosecutors, and the lead prosecutor being a senior deputy director of public prosecutions. We managed, to have Advocate Ndelo removed from the case, and then this new team took over and proceeded with the matter. And as they were proceeding with the matter, we kept on meeting, having regular meetings with them. When I say we, I mean myself and them, just to check what was going on, what problems were they faced with. And there were many problems regarding the mistrial application. Besides the 174s, there were mistrial applications. But we also had a safety net that was there, which I found already in existence, whereby there was private counsel involved, about 3 counsel involved dealing with the mistrial applications and giving advice, to the prosecution team. But what happened is, regarding the Ntelwa issue, I did say there must be an investigation. And I reported this to Advocate Rodney Jacob. But already when I took over, there were other problems that happened before I took over. But I picked up that the problem here was not just Ntelwa. There were issues about leaking of information, internal emails being sent out, and all that. So I said, maybe let's have a broader investigation to find out what exactly, is happening in the matter. We agreed with Advocate Jacob that investigation must be done. But I must confess that I said, look, we don't want to take these witnesses, have them interrogated about the internal investigation before they testify in court. Let's let them testify, and then thereafter, when the state case is closed, and then we can continue with the investigation. But that investigation has continued. In fact, last time I checked, there was an interim report on that, but the team had to be beefed up. The NDP already dealt with that issue. Then we pushed the case to the close of the state case, which was also a milestone for us, because if one has been following this case, you'll find that it has had many interlocutory applications along the way. It's been to the SCA, it's been to the Constitutional Court. It has a long history. But after the 174, which you mentioned earlier, there was also another mistrial application, which was dealt with, and we succeeded there. That is the 174 and the mistrial application. Now, coming to the issues of poor cross-examination and all that, my view was, let's just have a look again at the record, because I would be very disappointed if these seasoned prosecutors were not able to cross-examine, Omotoso on essential issues. And that is a subject of an investigation right now. But the other issue was the change of the prosecution team was not easy. Not easy in the sense that Advocate Ndelo had already built a relationship with these witnesses, and they found it difficult to proceed with the new team because, this is a sensitive matter. They had already had consultations with Advocate Ndelo, so it was not easy to transition, between Ndelo and the new team. But we managed that, until there was a smooth transition, and the new team built a relationship with the witnesses. which took us to the stage where the case was finalized. We accept that the case didn't go well. It didn't go in our favor, and we, on the other hand, let me say on the other hand, still I'm of the view that we appeal this matter, which we are doing now. And I don't want to preempt what the outcome of the appeal is going to be. But as a DPP, I am sort of confident that we have enough grounds to appeal the matter. And if I must, if I can just go back to the Ndelwa issue, Chair, you asked me a question about Advocate Ndelwa. We've removed him from the case. He's still working for the state. We've had to take away some of the work that he's doing and reallocate it to other prosecutors because of this, investigation that is still hanging over his head. So that is the position now regarding Advocate Ndelwa. So he is still on the NPA payroll, and also the three prosecutors that finalized the case that took over from Advocate Ndelwa are still in the employ of the NPA. There's a separate investigation that is taking place regarding the comments made by the judge about them, and Land Labor is also working on that issue together with the ethics office. The other issue is the whistleblower that was killed. The police are working on this matter. We are aware that the suspect has also been shot, but he was just a suspect at the time. But we will once again check with the police how far they are with that investigation. And again, if I must deal with the delays in finalizing this case has a lot of history, and a lot of applications took place along the way. And even the changing of the teams of prosecutions also affected the progress in the case. But when I assigned this new team, I said to them, look, this matter has been going on for many years. Please push it to finality, and I think they did their best to have the matter finalized. But we are appealing the judgment, Chair. We coming to what is a reasonable time. There is a team that's been assigned to deal with the appeal. I think they are on board here today. I think they can give a clearer picture. But I have made a decision to appeal the matter. There are papers that have already been filed, towards that appeal. There's still a lot more that needs to be done, in the matter. That is to make sure that the appeal gains some traction. Then there are other legal issues that we need to deal with, But Chair, I accept criticism. If my people, that is the last group now that I'm talking about that dealt with the Omotoso matter. I picked them based on their experience. I picked them based on them having won many cases of a similar magnitude in the past, And if in this one, they have bungled the case as it is alleged, and their cross-examination was very poor, I'll take responsibility for picking that team, because I did not just pick anyone. I picked people that I thought were capable of dealing with the matter. In fact, the first advocate that I put on board was Advocate Ntlakaza, which was now, I think it was around December 2021. And then 6 months down the line, he had to step down, you know, for other reasons, which are internal in the NPA. And then I brought in 3 prosecutors, a senior deputy and 2 senior state advocates that have years of experience here. So if they bungled this matter, I must say I would be disappointed, because this is a group that I trusted. This is a group that has experience. As for Advocate Ntelwa, you asked me what do I make of him, which is a very difficult question because the matter is under investigation. But my prima facie view, you know, I don't want to go into details for a matter that is still going to be appealed and there are internal investigations. But there are certain observations you make about your people. And one of them is there are people who are just not team players. You know, they would want to work alone, you know, and not want to share information. And unfortunately, Advocate Ntelwa is in that category. But that is a matter of, that is subject to an investigation. I don't want us to dwell on that. But I want to reassure you, Chair, and the committee that we going to expedite this, the appeal. But I think the members of the NPA that are part of that appeal process are here. Maybe they can elaborate on that. You know, again, Chair, like Honorable Musala, sorry if I'm pronouncing that wrong, I heard her sentiments, and I sort of want to align myself with her sentiments, but I don't want to say much about the judgment, you know, at this stage when the matter is as good as being sub judice. So I think that will be my input here. I don't want to come here with excuses. I put a team that I thought was the best team. If I add there, then the investigation will tell me that I add, you know. And whilst they were busy with the case, you know, I was with them, I walked with them, you know, to the extent that at some point they introduced me to the witnesses in the matter. And I wanted to make sure that there's a rapport between them and the witnesses. And at that stage, I was happy because previously it was not an easy transition. You know, when you replace prosecutors in a serious case like this, it's a sensitive matter because it you know, it's not easy for a victim to reiterate her story and tell her story to many people. It's not easy, you know, and I want to apologize to the victims for that, but it was necessary that we change the team, you know. So the internal investigation, Chair, is a broader investigation regarding whatever happened in the whole Omotoso matter. It's not just about Ntelwa, you know. Unfortunately, Mr. Sakata is not here because I took this case over from him. He would shed more light as to what happened before I took over this matter. If I'm guilty of anything, I'm guilty of bringing in these 3 people that, you know, finalized this case. And I intend to make that right. And I intend to make sure that this appeal, you know, is taken, if need be, to the highest court in the land. Thank you, Chair. Unless there's something else that I need to clarify.
Thank you. Thank you, Mr. Madolo. Chair, if I may just also address one of the questions that the Chair raised about the appeal process. Just to be clear that the decision to take, the decisions to prosecute or not to prosecute or to appeal a matter are legally within the prerogative of a director of public prosecutions, not the national director. But you are absolutely correct in terms of the section that you quoted. They work under the control and direction of a national director, but it excludes prosecutorial decision-making. That being the case, when there was an acquittal in this matter, I contacted Barry Advocate Mr. Madolo immediately, and respecting the fact that he is the decision maker on appeal. And unlike previous national directors who blurred this line and created lots of problems in the National Prosecuting Authority, I have been very strong in holding the line that as DPPs, I will not interfere in your decision-making processes, but insofar as ensuring all the things you mentioned, the support, ensuring that cases, their proper risk management that we've now put in place, there are a lot of lessons that we've learned from this. But as the national director, I've got to make sure that a prosecution has the best chances of success. And what do I need to do to hold DPPs accountable, as well as to give them the necessary support in cases? In this particular case, once there was an acquittal, I contacted the DPP immediately and I said to him, we are going to set up an outside team of prosecutors from outside of your division to look into this matter, to help you, because ultimately it is a DPP's decision, to help you make a decision on appeal. Not just people from outside, the best prosecutors in the country from outside of the Eastern Cape, but also we will get senior counsel from external to the NPA to help you make this decision. This was something the DPP supported, but it was something that I had said must be put in place, because given the credibility deficit that the Eastern Cape was facing, it was important. And this is not to cast, in fact, the lead prosecutor in this matter had to work with the internal team because, they needed information, etc. So he worked with them. But apart from that, it was a big external team. So that was put in place. The DPP supported it, and we moved with that. So in this particular case, the red flags were certainly raised, but before the change of the team. After the team was raised, as you heard the DPP, there were absolutely no red flags that were raised. The issues of cross-examination, etc., I would think surprised most people, including the DPP, when the judge mentioned it. So it's not like whilst the new team was proceeding, there was any need certainly for the national director to intervene, because there was absolutely no red flags that were raised by the DPP about. But yes, there were problems with the red flags raised with the first team. And we've explained what happened, but to give a little more detail if we need to. Just to mention that the application for the mistrial, and Barry, maybe you can help me out in terms of the dates, because I don't have everything right in front of me, but I think it may have been in my notes, I'm not sure, but was in 21 or 22, where the application for the mistrial was brought, specifically on some of the grounds that you mentioned, Chair, that there was the suborning of the witnesses. And it will be useful to read the judgment in that matter, because the application was not granted, because the judge found in that case that the conduct of the prosecutors did not amount to a mistrial. So those matters that were now raised in the main trial, and again, I find myself very constrained, because as the prosecuting authority, we argue and we legally criticize opinions and judgments in our papers. We don't do it in the public. Out of respect for the rule of law, we do not do that. And this puts us in a very difficult situation where I do not want to criticize publicly. But so when we can't explain everything. There's a gap in the understanding. So to be very clear that in that judgment, the application was not granted. And the issues that you mentioned were actually dealt with there. But the judge in the final decision certainly raised that as some of the reasons why she potentially could not decide to what extent the witnesses had been influenced. Now we have views on that, but I'm not going to explain. I'm not going to say anything more about it because the matter is under appeal. But I'm going to call on Advocate Mthunzi Mahaga, who is the head of our Legal Affairs Division, who is managing the process relating to the appeal, to answer some of the questions relating to the reasonable time issue, etc., which the chair raised. But before I do that, I'm going to call on Advocate Bonnie Curry-Gamwo to deal with some of the issues that have been raised, particularly relating to training and other matters. Bonnie?
Okay, thank you, NDPP Chair and members. If I may proceed, there was a question that was directed at me by the Honorable Paulson related to the killing of Ms. Pamela Makiti. Just to clarify that she was never a witness in the Omotoso matter, and my understanding from the prosecutors in the Eastern Cape was that the police there, the acting provincial commissioner there, has given a different reason as to why she may have been killed, the motive for her killing. I think that there was a request that in respect of the whistleblowing initiative that would be covered by the DG. In respect of training, so this has been a key priority for the NPA since its inception, that we have a training capacity within the NPA, specifically for gender-based violence, which covers all areas of gender-based violence, which is sexual offenses, it is the trafficking in persons, it's child justice, it's maintenance, and I said, yeah, domestic violence as well. So that training capacity is there with specified trainers, both at head office as well as within the various provinces and divisions as well. We have, and this training is scheduled every single year, and prosecutors are then trained, as I said, across the country. The material which we use is updated on an annual basis, where we take into account, when we do the review, we take into account all of the various amendments to the GBV legislation, and we make sure that everything is updated. The training, besides the scheduled training that we have every year, there's also ad hoc training that takes place all of the time, where DPPs are allowed to access the trainers to make sure that if there is a need for any assistance, that can be given. Now, following the Omotoso matter, I think it was Honorable Swart, you said we should do, it's an opportunity to do some reflection, which we, of course, we have done intense reflection. And so what we have now embarked on really is looking at what is our capacity in terms of GBV litigation. We have tried to, and we in fact succeeded in creating pockets of litigation capacity throughout the DPP offices, as I explained when I spoke earlier, when we spoke about prioritization. So there are pockets where we have these GBV vulnerable groups portfolios, where advocates, skilled advocates, resort within the DPP offices that are able to tackle the bigger cases. We also have the same type of capacity throughout our lower courts, where we do the training as I've described before. But upon reflection, we are now going to look at, because there's been a lot of changes in the NPA in respect of capacity. So you might have people that have been transferred, or new people that are coming into the system. What we are now going to do is we've created committees within the soccer unit that will look at, for example, how do we enhance victim management even more? How do we, and the second committee to look at how we handle matters such as an Omotoso matter. And the third one, training and competence or capacity of our prosecutors. So that is going to require a skills audit where we look at who are the people that are doing these matters and are they adequately trained? And where we find the gaps, we will immediately address those gaps because we have the capacity to do so. So I think training is probably one of the key areas that we are going to drive even more so now in respect of all of our prosecutors. But we will start with the ones that are specifically dealing with these cases in all of the levels of our courts, so whether it's the lower court or whether it is the high court. So that is a part of what we as the NPA will deal with. There was a question posed by the chair, and I'm not sure, Chair, whether I got you incorrectly, but I understood you to ask that there was a letter that was written by the victims in this matter of Omotoso to the NDPP about the dissatisfaction with the prosecution team. I am not aware of such a letter. What I am aware of is a letter written by the victim, one of the victims, to the office of the NDPP requesting that Mr. Ntelwa actually remain on the case because they have confidence in Mr. Ntelwa. So I just wanted to place that on record as well. Thank you.
Thank you, Bonnie. Chair, if Advocate Mahaga can deal with the legal issues and the processes and the reasonable time that we hope to lodge the application for leave to after all of the processes before that.
Good afternoon, Honorable Chair and Honorable Members. Thank you, NDPP, for the opportunity. I'm on the road to the Eastern Cape, so if I get cut off, please bear with me. I just want to highlight the fact that when you are invoking Section 319, which is a request for the judge to reserve questions of law for consideration by the Supreme Court of Appeal, 319 does not stipulate the time frame. However, 311 and 316, which are ordinary appeals, do stipulate 14 days and 21 days. But we undertook to do so within a reasonable time so that there is no undue delay. But then when counsel went through the transcript and the the judgment that was delivered on 2 April 2025, we struggled to identify factual findings that warranted the rejection of the evidence of each witness. And the case of the Supreme Court of Appeal, the judges there made it clear that the prosecution in a case of DPP versus Western Cape, DPP Western Cape versus Skuman and another, it is wrong to craft questions of law for consideration by the Supreme Court of Appeal in the absence of clear factual findings, because you are likely to commit a mistake of construing questions of fact to be questions of law. Then our SC said or took the view that we supported to say, let's first seek clarifications on the factual findings so that we finalize our provisional questions of law, which we did on Monday, and the registrar of the High Court in Gqeberha confirmed the receipt thereof. But there was an indication that the Honorable Judge, since he's on retirement, is not available, will only be available next week to respond to us. Now, the important part of it is that we can't commit the same mistake that was committed by prosecutors in the Western Cape in respect of the SCA judgment. And it's clear there. I've made it available to some people who were asking questions as to why, when the judgment was read live on TV, are you still asking for reason? And I said, we're not asking for reasons. We are saying the factual findings are not glaring. If those are clarified, we will then say, you failed, Honorable Judge, with respect to apply the principles or the law
into those facts. And the factual findings that we made make us conclude that when you applied the law, you did so wrongly or you misdirected yourself with respect. But there are provisional questions of law that we've crafted. We will then, once we receive that clarification from the Honorable Judge, finalize them and submit them. But the timeline will start kicking in when we receive those factual findings. I'm not sure if there's other issue that I needed to clarify when it comes to the appeal itself.
Thank you, Advocate Mahaga. Can I come to Ms. C.D. Modise, who will deal with some of the issues relating to proceedings against prosecutors, labor-related issues. C.D. is the head of our HR Chief Director in the NPA.
Thank you, NDPP, and good morning, Chair and members, honorable members. The question that was raised was relating to the timeframes it takes to do an investigation by law or prescript requires that it should be finalized within 30 days. And in terms of inquiries, we have 60 days to complete an inquiry once it is set. But having said that, the chairperson of the hearing, once there is a first sitting, has the determination to extend the period, particularly if there was suspension involved. That would address the issue of how long it will take. And there was also a question of protection of employees and the employees and support, employees wellness and support that we give. We have a contract that we enter into with external service providers that provide for wellness and support to the employees. We do proactive support where we do not wait for complaints, but we also have a reactive mechanism systems where whenever an issue is brought to our attention, we then deploy. The reason we use an external service provider, obviously we're not a health and wellness organization. So we are able to access doctors and psychologists and nurses through that program. And as well, we are able to have a national reach in all offices. We do have a limited internal support for those employees that feel that they need support internally, but it's only limited in terms of that, in that regard. And we also end up doing that online because we cannot reach the whole of the country. But in terms of making sure that prosecutors are supported, it is through the service provider who has a national footprint in all the offices and is able to reach all the prosecutors. We in addition to that, we on a regular basis, we conduct trauma debriefings given our environment that we do with prosecutors to make sure that they are debriefed. And we also give them skills in handling conflict because they work in a environment that is full of conflict. So these are some of the things that we're doing, but we are available and we have made sure that the contract that we enter into or the SLA with the service provider is that they've got to respond within 48 hours whenever an issue is raised for them. I think on the issue of suspension of the prosecutors, Advocate Berry has indicated that we did not suspend them because it is an after effect. The purpose is not going to be served because the investigation is on facts that have already happened. And we have from the labor side working together with the Office for Ethics, OEA, we have set up a team, and we have in that team, we have a person who's full-time placed in the investigation team to make sure that the investigation is finalized as soon as possible. The agreed time is by the middle of June, they would have finished. And by the middle of June, because they had to go through all the transcripts to be able to determine if the prosecutors failed, or as the chair has asked, whether they were deliberate or just incompetence or something happened beyond what we could see. So it is we need to go through the investigation team needs to go through all the transcripts, and as you know, that was a long trial, so the transcript is very long, but the indication and the commitment is that we will get a report by the middle of June, and which will also make a recommendation in terms of what action, further action we need to take against one or all of the prosecutors that were involved in that case. But having said that, we also, one of the things that we got is to not prosecute, not to discipline prosecutors for doing their job. And hence we needed to wait, and we needed to have a formal investigation to find out if there was a misconduct, so that we don't create a scare with all the prosecutors to make a decision, because they have to make decisions every day on all the dockets. And if we are going to be on their case and disciplining them for everything that they do, they are going to end up not making decisions. So we're mindful of that. But as I say, the reliance on these investigations is more on the transcripts than on anything else. There was a question about the protection that we offer to the prosecutors. The protection obviously is not given from HR side, but whenever there is a threat, it is reported, and proper measures are put in place to provide VIP protection for them. But also in some instances, you find that the solution is just to temporarily transfer a prosecutor to a safer place, which will then come to us, and we do that. So whenever there is a reported threat, we do react to those threats, and we put measures in place to ensure that the prosecutor is protected. Unless I have missed something, NDPP, I think those were the issues that were raised.
Thank you. Thank you, Sidi, Ms. Mahaga. Modise, can I ask Advocate Mziniati whether there's anything more that MPS would like to add? I have some further responses that I need to deal with. Can I hand over to you if there's anything from your side, any of the NPS colleagues want to add anything to some of the responses?
Good afternoon, Chair and committee and everybody on the platform. No, NTPP, I've been following the proceedings up to so far, and everything that relates to the NPS, I think, has been sufficiently covered. So I've got nothing to add, Chair and NTPP.
Thank you. I'm going to come back to Bonnie after in a bit about the withdrawals. That was raised by one of the colleagues, as one of the honorable members as well. And Chair, just to say that we have been categorizing, because there was a lot of overlaps between the questions. So we've been categorizing and trying to deal with all of the questions. I know there's some that's still outstanding that I will deal with. But if we haven't dealt with any, we would please, if the committee can please remind us. And so we could, there was one that I said, there was one on the OEA, and there was wanting to requesting know more about it and what it's doing. If we can ask that, we will provide its mandate, etc., provide a response on that in writing. I'm going to ask Bonnie to please come in. There was a question about the withdrawals. If you could deal with that before I deal with the outstanding issues.
Thank you, NDPP. The issue of withdrawals, I'm just going, the matters withdrawn. I think that it came from Honorable Sali. It was around the matters that are withdrawn and the matters that are underreported. So in gender-based violence, I'll start with the second part first, which is the underreporting. Underreporting in gender-based violence matters throughout the world. That is a huge issue. And so a lot of work is being done in the prevention sphere by the NPA through its public awareness campaigns with other stakeholders within government, also with civil society, to speak around empowering our people out there to be able to understand the need to report and what is available for them in terms of victim management, in terms of cases, in terms of the criminal justice system for when they do report. But that is an ongoing battle, but it is also a key priority of the NPA and will continue to be so. just to note that even in the TCC sphere, you know, we've seen an increase in the number of people entering the TCCs, and we would like to think that it is because of this public awareness that we are busy with throughout. In respect of the matters that are withdrawn, matters that are withdrawn can, of course, be enrolled again. So most, and again, I speak in a GBV environment, most of the time, the reason for the withdrawal in the past has been because of DNA. That does not seem to be the case right now. We have introduced a prioritization in respect of the DNA capacity. And so because of that direct link that we now have with the Forensic Science Lab, we have been able to say that we do not have cases anymore that is being withdrawn because of a lack of a report, a DNA report being outstanding. Matters are also withdrawn because often victims, despite receiving psychosocial services around trauma containment and ongoing counseling, often are still not ready to proceed at court. And so we need to always place the victim first, their rights, their dignity must be protected. And so therefore we do at times withdraw as a result of a victim not being ready to proceed. So again, various reasons why matters are withdrawn, but we do try and emphasize the re-enrollment of these matters. When you look at how we engage with our prosecutors during our training, we do emphasize that withdrawals in the GBV sphere must be managed as a priority so that those matters, whatever needs to be done in respect of those matters, are done as soon as possible, and so that those matters can be re-enrolled again. Thank you.
Thank you, Bonnie. Chair, there's some other matters that I want to deal with that have not been covered. Firstly, the question by the Reverend.
Please watch your mic.
Question by the Reverend about, there were two aspects I think that haven't been covered. About he said willing to meet victims. It's not just a willingness. I actually reached out through the DPP in the Eastern Cape saying that I wanted to meet with them and to arrange the meeting. The DPP indicated to me that they were at that point not willing to meet with the National Director. I also expressed this too when we met CRL. I again, because I know that they have been giving very good support to the victims, again, said that if they could arrange a meeting, we would be very grateful. And the reason is, yes, of course, you know, it's been devastating impact for the victims. And I want to hear them. I want to listen, to really deeply understand how they feel the prosecutors in this matter let them down, how they feel. And so that we want to learn from this. We want to make sure that no victim ever goes through this again. It's hard enough having to face an acquittal. But if the prosecutors actually, re-traumatization is something prosecutors get a lot of training on to make sure that we do not add to the trauma of victims. So I really want to hear so that we can make sure that future victims do not ever experience what they did. The Reverend did speak about an apology. I certainly understand the importance of an apology. We are conducting various investigations, and once those are done, I will certainly look at what the options are in that regard. But I want to understand the victims, and I want to look at it very, very carefully. Right now, there's a legal process, there are various investigations. These must be allowed to take their course. And once the investigations are complete, I will then know exactly how, or certainly consider what the best options are. But right now, we feel the pain of the victims. And I want to say to them here and now is that you've done nothing wrong. And then on the issue of prioritization, we were asked a question. Yes, prioritization is a huge part of the NPA. It is one of our strategic imperatives. And the reason for this is because, well, there are a couple of reasons, but one of them is that we will never be able to prosecute all cases. We have to prioritize to ensure that we prosecute those that make the most impact. So there are various criteria that we consider, but it is important to prioritize. And so what we do is, in the context of prioritization, we've now added following lessons that we've taken from Omotoso, that in addition to simply submitting reports, all DPPs, Directors of Public Prosecutions, are required to do a thorough risk assessment of every single high-profile or high-impact case to identify all of the risks, whether it relates to capacity, whether it relates to witnesses, whether it relates to security, the evidence. It shouldn't be the evidence, because we should prosecute when we know that we meet the threshold of a reasonable prospects. But to identify all the risks, and then to make sure that there's clear risk mitigation plans. And then from the national office as the national director, I will monitor that and make sure that there is the least possible risk that a high-profile, high-impact case can fail. But DPPs in their divisions, of course, can do it more broadly, but this is with regard to the high-impact cases. It even relates to the issues that you mentioned, Chair, one of the members, about the skills of the prosecutor. Who are the prosecutors? For me to understand the rationale behind selecting certain prosecutors in high-profile matters. Do they have the skills? Have we done certain level of inquiry into whether this will be the best prosecutor? There's no conflicts potentially. So there's a lot of work that's going into all of these matters now. Dealing with, and that actually also addresses the question about, taking action after something is reported in the media. That is certainly not the way we operate. We have already we've put in place a lot of things already to deal with ensuring that high-profile cases have the best chances of success. But we're taking lessons and we're actually strengthening those measures to ensure that it's not about when something ends up in the media that we are reactive. We've got to be proactive in protecting a case and ensuring justice. In terms of the timing of the investigations, we were asked questions about why the investigations into Prosecutor Ntelwa and others were not commenced at the time when the allegations were, the DPP became aware of them. And it's a no-win situation. Damned if you do, damned if you don't. This is a situation where I can almost guarantee you, if at that time we decided to proceed with this investigation into the potential misconduct of prosecutors, when the witnesses and victims still had to testify, I can almost guarantee you we would have been crucified for being insensitive to victims and proceeding with this when in fact we should have waited until they testify. There's no win situation. So we assess the pros and cons and do what we think is in the best interests of the victims. And of course, consulting with them. And I imagine that the DPP would have done all of that work before he and the DNDPP advocate de Kock decided it was in the best interest of the victims to delay that investigation until the end of the state case. So, it's a question of really trying to, there's no good situation. It's really trying to deal with which is the better of very difficult situations. There was a comment about the NPA being insensitive to the working class. I think prosecutors will feel very offended by that. From the outset, I recall from the days of Advocate Piccoli, who was the national director, he always said, we must always have a bias for the poor. And it's something that I have been repeating to prosecutors, to DPPs, that it's the poor that we must have a bias for. The powerful and the rich can have a lot of power, but the poor are the most vulnerable, and they're the ones that we must really take care of. And so we do work with the bias for the poor. On the issue of, there were a number of questions raised and the NPA criticized for that don't deal with the Omotoso matter. I'm not going to deal with that. If there are questions that in writing that could be sent to us, we'd be happy to deal with them. Witness protection, I'll leave to the DG. There was one of the honorable members talked about the gaps in the system. And I think I really appreciate that this was actually raised, because of course there are huge problems in the criminal justice system. If people want to make the NPA the scapegoat for it, we'll have to deal with it. But I hope that there is a very, very strong realization and that we understand our role and we understand what our mandate is. And I'm not trying to be defensive about the role of the NPA. I'm trying to perhaps create a better understanding of the fact that things start with a docket. It goes through a police process. It comes to the prosecution, and so it goes into a court system. And there are various things that can work or cannot work at various parts of this criminal justice process. The honorable members mentioned the forensic lab issue. This was a matter that was raised at the National Efficiency Enhancing Committee meeting, which is chaired by the Chief Justice and all the heads of court, chief magistrates, regional court presidents attend this, as well as defense, various role players. It's a very, very well attended meeting where the issue of the problems with forensic, the capacity to deal with forensic analysis and the challenges in some provinces, in particular KwaZulu-Natal, was raised. And these are things that have to be addressed. Otherwise, we're always going to be dealing with the backlogs in our system and various other challenges in the criminal justice system. There was another question raised about the balance between an appeal and deportation. And I know the DG of Justice is on this call. This is not a simple matter. And in fact, the honorable member who raised this, in fact, raised issues that conflicted me as the national director. And I'm going to be very candid and open about this and share what I can. Yes, of course, you have an appeal process, and you wouldn't want a Gupta scenario where a person is out of the country and you can't proceed with an appeal. So as the key entities in the JCPS cluster, we came together. So it's not a question of the right hand not knowing what the left hand is doing. The DG of Home Affairs, and I want to be very clear, because again, the NPA is being blamed for what's happening in a deportation process. That is not an NPA process. That is a Home Affairs process, and no one should be blamed for it. It is a legal process. So this is not a prosecution process, but the prosecution supports the Department of Home Affairs to the extent that there may be evidence that needs to be led in that deportation, which is a quasi-judicial process before a magistrate. And that is the support that we give. But there was a meeting between the DG of Home Affairs, the DG of State Security, a representative from State Security, the National Commissioner of Police, the DG of Justice, the DG of Correctional Services. No, it wasn't Correctional Services, it was Home Affairs, and the National Director. When these issues were dealt with, and the legal process is a separate process from the deportation process. And again, there are pros and cons, and I don't want to go into the detail, but the legal process we know will take a very long time, the appeal process. And well, we suspect strongly, let's put it that way, given what we know about accused person with means, these processes will go right up to the Constitutional Court, and an appeal process could potentially take years. And in that process of this appeal, you have a person that the country considers undesirable, and I'm not going to use the words that some of the honorable members used to describe the Mr. Omotoso, but where it clearly reflects the feeling that the country has. So you have a long appeal process where you have a person that's been acquitted, so there is no legal basis to hold a person like that in this country. And there will be an outcry about the long appeal process, and that someone who many of the honorable members have in fact said they regard this person as a threat to women. I'm not saying that. All I'm saying is that is the way the feeling is. So the deportation process has been welcomed by victims. And so that process will continue. It's separate from the appeals process. And when the appeals process is finalized, we will, and there it could be successful, or it could go one of two ways. So in the event that it's successful, we will have to consider what needs to be done in order to ensure that the accused faces justice. But I want to be, make it very clear that these are very complicated issues, and we're trying to be as transparent and as open as possible with the public so that you understand that these decisions are not made in a vacuum, but these are very complex issues, and we're trying to ensure that we deal with it in the best way possible. Chair, before I deal with the Pretorius issue, you asked about the appeal on the facts. The NPA has made representations. You are correct. The DG is online. The issue of the state being able to appeal on a question of fact has been something that we have been raising for a long, long time. But now that the review of the Criminal Procedure Act is being dealt with in the department, we have made many submissions to the department. And this will certainly be something that we would like Parliament's support on, in terms of strengthening the prosecution hand in order to deal with matters where we think the judge has erred, not just on a question of law, but also with regard to the factual findings. And then with the issue of the appointment of Advocate Pretorius, this matter has received a lot of attention in recent times. The DM himself answered questions in this regard just this week. Just to say that the NPA has been given a task, a very difficult task, which the country is clamoring for justice for those responsible for state capture, which we know brought our country to its knees. As the NPA, we want to try to get the best possible capacity and capability to do this. And we do know that there are some that will want the NPA not to succeed with regard to this. And so we want to bring in the best, but making sure we do it legally and we do not compromise anything with regard to conflicts of interest, etc. So Advocate Pretorius has already worked for a 6-month period in the NPA. This was an extent to renew or to give him another contract for a 6-month period. He's brought on board because of his expertise and knowledge with regard to the evidence in the Zondo Commission. He's not involved in prosecutorial decision-making. He's a strategic case advisor, which will help us actually fast-track cases and move them quickly. So, there's absolutely no question of a conflict of interest that arises. But I do want to say that we are looking into this legal. Advocate Pretorius is being brought on board for that purpose. But we are looking at this matter legally, and our prima facie view at this stage is that even if it's a prosecutor, and it isn't in this case, that this is in fact a red herring, and that is not a conflict of interest. There have been judgments in this regard that we're looking at, and so we're going to get a proper legal opinion on this, and we'll be able to deal with that. It's not arisen because, as I said, it's not our intention to use Zondo Commission officials as prosecutors. That's not what we're doing, but it's not my point is that it's not an issue even if we were, but we're not. So that is the point. That's the response with regard to Advocate Pretorius. And I'm not sure if I am not dealing with, oh yes, and I think I must finally address the issues of the call for the NDPP to stand down. I think that if, as the National Director, I was of the view that we're failing in the NPA, and I am failing as a national director, I would be the first one to step down. I am not here to hold office for any reason but to serve the people of this country. And that is why I'm in this position. I have no problem stepping down at all. And I would like to say that I have that level of insight into whether I can do this job or not, and whether I should be in this position or not. I think it would be great if we had a culture in this country where people step down when your integrity was seriously impugned. We have done incredibly good work since I took office. And now, I don't want to sound defensive. I really don't like doing this, but I need to respond to calls that as a national director, I should step down. We took office at the end, I took office at the end of state capture, and we had to turn around a captured institution. We have done incredibly good work. And I know this has got nothing to do with the Omotoso matter, but I'm responding to questions. We have done incredibly good work in turning around the NPA, which is now a professional, well-run, reasonably well-capacitated prosecuting authority that has prosecutors of the highest standards of integrity and professionalism. Of course, you will have prosecutors that don't meet this standard. That happens in every organization. And when that happens, we must make sure that we deal with it in a manner that is fair, in a manner that is swift, and to ensure accountability. And so, to the prosecutors in the NPA, I want to say to you that we are not a failing organization. You are not failing prosecutors. I want to commend all of you for the incredible work you do every day under extremely difficult circumstances. Many of you under protection, prosecuting gangs and some of the most violent criminals in this country. This is something we have to deal with, but certainly at this point in time, I'm incredibly proud of the work that the NPA has done. I have no intention of stepping down. And sure, if, the processes must take its course, but my commitment is to the people of this country and to keep fighting for justice until the last day that I can legally be in office. Thank you, Chair.
Thank you, DG. DG.
Good afternoon, Chair.
Yes.
The DG had to step out of the meeting, but I'm still in attendance and I can answer some of the questions if that's permissible to you and the committee, please.
Proceed, DG, please.
Thank you very much, Chair. Let's deal with the first issue of the minister's and the report sought by the minister. Yes, the minister did seek a report from the NDPP with regard to the Omotoso case, and she was in receipt of a report, and she subsequently sought a meeting with the NDPP and relevant officials to discuss the outcomes of this matter. And of course, the minister has expressed a concern about the case as well and its outcomes. A meeting was held, and there are still ongoing engagements between the NPA and the department regarding this case in particular. Obviously, there's many processes in place, investigations, and the reports on doing an appeal, etc. And so it is understood that the NDPP will provide further reports to update the minister and to deal with the issues that the minister raised in a previous meeting held with the NDPP. That is insofar as the minister's work is concerned. And I think further reports can be made available by the minister and the DG themselves at an appropriate time should the committee so require. Then, Chairperson, there were questions around witness protection and whistleblower protection, which arose in the case or in the instance of Pamela Mabini. And some of it has been answered by the NPA insofar as that specific case is concerned. There's two pieces of legislation, Chair, that we need to take note of. One is the Witness Protection Act, where witnesses in a case are given certain kinds of protection after they meet certain requirements, and that is the unit that is currently housed within the NPA. And when it comes to whistleblower protection, we are talking broadly about the Protected Disclosures Act, and you will note that the department has completed some research, consulted on it, and we are now looking at amending legislation to offer broader protection to whistleblowers, but not necessarily only in the criminal justice sense, but also where whistleblowers make information available on all types of crimes. So that process is also underway. On the Criminal Procedure Act, the Law Reform Commission is completing the review of the Criminal Procedure Act. 4 papers were put out for public consultation and was released by the Deputy Minister of Justice together with other members of the JCPS cluster, I think around April or earlier. And the 4 papers relate to arrest, bail, alternative dispute resolution, and non-trial resolutions within the criminal justice process. So while those amendments and comments are coming in, the reports will be updated, and we are moving on to areas on the Criminal Procedure Act related to the trial phase and the post-trial phase, such as how do we ensure more efficient and speedy trials, etc. So that work is underway, and we expect the bill to be ready by September 2025. Chair, is there anything else that you wish me to respond to?
No, that's fine. That's fine. I'm not sure if you're aware on the progress on the Section 33 report that was invoked by the minister to the NDPP.
Yeah, that was part of the first response that I made.
Okay, that's
Yes,
fine.
thank you.
Thank you, Pile. Members, I think someone is saying chair.
Honorable
Honorable,
Mhlala.
yes.
No, thanks so much, Chairperson, for the responses from the team from NPA. We heard the responses, but we want to tell Advocate Shamila Batoyi that she will never see mistakes on herself. We, as the country, we are seeing a lot of errors on her side. And we are requesting her nicely to resign as soon as possible. And with regards to the issue of Advocate Pretorius, we have never said that there's anything wrong with the act. We are saying, we've never said the appointments were unlawful. We've said they are ethically repugnant, politically motivated, and represent the textbook definition of conflict of interest. The NPA maybe doesn't understand this, or worse, pretends not to, proves how far the institution have drifted from integrity under Shamila Batoyi compromised leadership. So, Chairman, the same man that Advocate Batoyi is trying to protect here is an independent actor. He has represented Steinhoff International, FNB, and ENS Africa, all entrenched in corporate crimes and capitalist exploitation. His career has been defined by defending the powerful, and he cannot certainly transform into a crusader for justice. His reappointment is not a legal necessity. It is a strategic placement of a politically safe, elite-friendly insider into the prosecutorial core of our democracy. So we are not protecting anyone in state capture cases as we had her representing here. But we are saying what you are doing is wrong, and Advocate Pretorius is not the only person who can handle those cases. You told us here that we have proper people in the in NPA.
Thank you, Honorable Mhlala. We'll take those as your submissions in relation to the matter at hand. I think the first part, the NTPP has replied on it that she's not going to resign. The second part, I was about to request the NTPP to prepare and submit a comprehensive written report on the issue of the appointment of Advocate Pretorius to the committee. Then we'll look at it closely. Then we'll take it from there. I think, members, thank you very much for...
Chair, before you close, if I may on that.
My hand is up, Chair. I don't know if you saw it.
I didn't see it. Okay, let's do like this. NTPP, can you
Just
hold
on the point, just to say that Advocate Pretorius has not yet been appointed. There's still a process. So
I'm coming to you, Honorable Nomvalo. Please wait a little bit.
So we haven't yet decided what the process is ongoing. Would you want a report now or in the event that he is appointed?
Yeah, I
because
think
he's currently not in the NPA.
Okay. I think in the event that you appoint
sure.
Pretorius, you write to submit a written report on
Sure.
it. Honorable Nomvalo.
Yeah, just in 2 minutes, Chairperson. Firstly, I think the narrative that we're always spreading that the NPA is disorganized has also manifested itself here by the manner in which they were responding to questions. We are used to a concise and a chronological way of responding to questions. The manner in which they've answered to our questions, Chairperson, on its own is a call for concern. We are used to a method wherein members to whom questions have been posed, one, they note down the name of members who have asked those questions. And when they respond, they say, now I'm responding to questions of so-and-so, Mr. Nomval. So that by the time when your questions are responded to, you also note down so that if there are questions which have not been responded to, you make a follow-up and you remind the chair that, Chair, there are these questions which I've asked or that I've posed, but they have not been responded to. So we are not used to this kind of disorganization that has displayed itself here. Secondly, I think, Chair, you have alluded on the details or on the section under which I asked a question to Advocate Batoi, section 22, and you did justice by going into subsections. But I had asked a question about the statutory obligation that she has now as the NDPP. And again, she has given a dismissive response, like like she always does, and like she did on the case of Siniswa Magaqa when we were asking her. She says to us that the matter was not brought to her attention, and had it been brought by the DPP, then she was going to intervene. And she goes on to say she didn't want to interfere. There's a difference between interfering and intervening. When you are given a leeway by the statute to intervene, you are not interfering, you are just executing your statutory obligation. Hence, our firm belief that Advocate Batoi failed to exercise his statutory obligations in this matter from when it started, because this is a prominent matter which was making rounds, the prominent matter which was on national television. Now, if you are a responsible and an efficient a person, you would have taken advantage of this matter in order for you to showcase your strengths, the strength of the institution. Now, this matter has caused a great loss of confidence by the public to the NPA. We just wanted to make this point. Lastly, Chair, you can't dance for your own maturance here. We are the judges as the people. It's us, it's the public that can judge your performance. You can't tell us that you have done good and so on and so forth. Whereas the public has a great feeling of unease about the performance of your institution. And you come with arrogance here. You are telling us that we are not going to resign because we have done good. You took this institution to greater heights. I mean, it's the work on record that should tell us that, not your words from your mouth. We must be seeing that from what we have done in terms of executing your responsibilities. You are failing to do simple cases. I mean, it was an embarrassment that Afroforum took a simple case which the NPA failed to prosecute, an assault case, and Afroforum, a right-wing organization, a racist organization, outshined the NPA. A shame. What a shame is that? And you have the audacity to come to this committee and tell us that, no, you did well. You can't dance for your own maturance here. You can't be the judge in your own case. It's the people who must judge your performance. And we say on record here as the NPA that you have successfully collapsed that institution. You have dismally failed to do your statutory obligations as the NDPP. Thank you very much.
Thank you. Honorable Mvalo will take those as the submissions. Honorable Tsotetse.
Thank you very much, Chair. You know, Chair, I'm worried about the aspersions that have been cast by, or rather insinuations that have been made by the NDPP when she wants to invoke a reverse psychology strategy on the members of the committee and suggest that perhaps the fact that all of us were saying that we are noting certain degrees of incompetency on her part as a leader of an institution, that we are saying all those who are involved in the organization are incompetent. That is not what we are saying. And the continuous effort on her part to try and act like she's encouraging prosecutors to remain focused in the work that we're doing. Of course, we have noted that indeed there are areas wherein those hardworking prosecutors have outdone themselves. But we are saying the NPA has a challenge of leadership which directly points to her. We are saying that the NPA has subjected the country into a serious embarrassment, that the NPA has presided over the process of undermining the struggle against gender-based violence and femicide, and that as a leader of an institution, it is only fair that she does an honorable thing, like those that have always called for everyone who's leading an institution, when the institution fails decimal, that they must do an honorable thing. We're repeating the same call to her to say, what is wrong with you, NDPP, taking a decision to resign in the face of an embarrassment which you have caused the entire country in the case of Omotoso. That is what we are saying. Now, I think that it's unfair that all these calls, you know, if this institution chair was led by a black person, I can assure you that these calls would have even enjoyed support of some NGOs which are right-winged and so forth. Now, in this country, we are failing to recognize the incompetencies, particularly when they are coming from people with a better card than black. The NDPP has an obligation to fall into her sword. She has failed the struggle against gender-based violence, and that's what we're saying. Thank you, Chair.
Thank you. We'll take those as your submissions. Honorable Mazin Paulson.
Thank you very much, Chairperson. Chairperson, I'd just like to know from Advocate Batoy, since Home Affairs is planning on sending Omotoso back home, is the NPA planning on intervening to ensure that he stays in the country and also at the same time stays out of harm's way where he cannot cause further injury to our women? And also, Chairperson, I notice once again the NPA is dodging the issue of prosecuting those South Africans who go and participate in the genocide of Palestinians. We have a duty as a country to do everything to prevent a genocide. Part of that is prosecuting those who go and participate, and there's prima facie evidence that those people have gone and participated in the genocide. They posted all over social media. If anyone posts a vehicle that he just bought, the SARS would be onto that person to make sure that he pays his taxes. Yeah, someone goes and show on social media how they committed or how they participated in a genocide. They brag about it. And the NPA does nothing. We report these matters to the NPA. They don't investigate. They don't prosecute. They don't care. It is our duty as a country to do everything to prevent a genocide. It's gone so bad now that members of parliament are now becoming criminal to go over there and to go and whitewash apartheid and the genocide.
Chairperson, point of
And
order.
when we report those criminal MPs to the NPA, are
Honorable
they
Paulson.
also going to be?
Honorable
No,
Paulson.
man, this guy can wait.
No, wait.
Chairperson, point of order.
A point of order against you. Honorable Swart.
Chairperson, it's very late in the day. I'd request that you rule that dispersions are being made about members of parliament and that we can conclude this matter as quickly as possible. Thank you, Chairperson.
No, maybe Honorable Swart, I would have thought that you will raise the fact that it is not relative to the issue at hand. So maybe can we, Honorable Paulson, can we request that the NDPP answers in writing?
No, Chairperson, I'm not done yet, Chairperson.
What's
And
your
Chairperson, I don't care how late it is. We
wait,
were
Honorable
elected
Paulson,
by the people of this country to represent them 24/7. No, there's
Point of order,
there's
Chairperson.
no checkout time for
Honorable
MPs.
Paulson.
Point of order, Chairperson.
Wait, members, wait. Please.
Chairperson, all the apartheid denialists are coming
No,
for me.
no,
Are you
no.
going to
Honorable
protect me
Paulson,
from
don't
them?
do this. Honorable
Protect me from the
Paulson.
apartheid denialists, the
Honorable
people that
Paulson.
go and are complicit in the
Honorable
genocide of
Paulson.
Palestinian people. Protect me
Honorable
from Glennis
Paulson.
Breitenbach and that stinks
Honorable Paulson. Honorable Paulson. Honorable Paulson. Honorable Paulson.
You said my name 4 times. I'm waiting, Chair.
We are quiet, so that's why I'm not sure if you can hear me. I am saying to you, because the question is not relative to the issue we are dealing with today.
We are dealing with the NPA. It's relevant to the NPA.
No, wait, Kaluborum.
No, Chairperson, you are now shielding the NPA.
I'm not shielding. I'm not
And
shielding.
the apartheid denialists, you are shielding them. Because they know they're guilty.
I don't need
They're
anyone
going
to
to jail.
chance. No,
They're going to
Honorable
jail.
Paulson. Honorable Paulson, please, listen. I am saying there are a lot of issues that are actually relevant to the NPA. A lot of them. We can raise them until the end of the year. But we're saying what we are going to do. The same thing that we were saying with regard to the issue that was raised by Honorable Mhlala of Advocate Pretorius. Because it's not now relative to the item on the agenda for today's meeting. can they answer that in writing? And that will be shared to all the members to indulge on, including yourself. Because the problem now is that whether your sentiments are right or are wrong, they are now taking us to a different turn of the meeting. What is going to happen now? This matter has been discussed even in the House. So this matter, the House dealt with. I know that even parties who have made submissions of what must happen in regard to what was discussed in the House. So I don't want you to drag this meeting to what has been taken, what has taken place in the House. And I'm sure we're going to receive reports of how the matter is being handled by Parliament. So can we now specifically deal with the issue of what would have been, wait, Honorable Mhlala, I said everyone must wait. So that we don't.
I thought you were done. That's
No,
why
no,
I'm
I'm not.
saying, okay, okay.
No, no, I'm not
Chairperson,
done.
Chairperson, when you're done, could I just
Not done. Wait.
have 1 minute to respond?
Wait, Honorable Paulson. So what we're going to do, Honorable Paulson, will allow the NDPP to respond on the deportation issue that we have just raised, which is very important for purposes of this meeting. Because we understand that if Mr. Omotoso is deported, on the other hand, we're in court, we'll have to do an application of extradition and all the strenuous process. So it's a very important question. Now, the issue relating to the prosecution of those who you think they are participated in genocide and stuff, can we allow NPA to do a written response on the matter? And I'm also highlighting that this matter has been dealt with in the House as well. Can we do like that, Honorable Paulson?
Chairperson, we'll wait to hear from the NPA, but I would just like you to remind the Honorable Steve Swart that it doesn't matter what time of the day it is, we were elected to represent the people of this country 24/7, not part-time, Chairperson. Thank you very much, Chairperson.
That's fine. Honorable Bredenbach, your hand is lowered. We have dealt with this matter.
I'll
No,
abide by your decision,
wait,
Chair.
Honorable Mhlala. There are people who raised point of orders before you. Wait. Honorable Bredenbach, the matter is sorted now, ne?
Yes, I abide by your decision, Chair. Thank you.
Thank you very much, Honorable Bredenbach. Honorable Mhlala.
No, Chair, I just want to raise order on your ruling in terms of the question or my input on Pretoria's matter. Earlier, before we started, you promised this meeting that the NPA will respond. Let's allow NPA to respond. If they don't have answers, they will speak for themselves that they don't have answers. Then they will therefore resolve in writing the response. So I don't agree with you when you said to Honorable Paulson that you are including the matter of Honorable Mhlala of Pretoria's. It is also going to be addressed in a form of written response. Let them respond here. We are waiting for these answers. The people are waiting there. They want to hear exactly. Yes. The other thing, Chairperson, let the people not be agitated when we are raising questions here. I saw majority of these other parties, the right parties, they now raise hands.
No, Honorable
noise
Mhlala.
here, instead of just allowing the process to unfold as it's supposed to be. Honorable Paulson is raising a very genuine issue and it answers here. Thank you so much.
Dealt with that matter, please. And the NDPP did make a response on the issue of Pretorius and went to an extent that Pretorius is not with the NPA currently. So the matter has been dealt with.
But I came back now, Chairperson.
Let's not do a back and forth, please, Honorable. Please. NTPP, can you touch on the issue of the possible deportation of Mr. Timothy Omotoso?
Chair, I hope you've noted my hand.
You did not raise your hand, you just appeared on the screen.
No, I did, Chair. I just thought I don't interject when you speak.
Okay, you are going to do a follow-up, Honorable Mani?
Yes.
Okay,
Quick
let's
one.
take the follow-up. NTPP, can you pause there? Let's take the follow-up so that the NTPP covers both.
Thank you. No, it's actually a parting shot, Chair, from my side, just because the NDPP has confirmed that all these things that we are saying to her is water under the back of the duck and all of that. So I just wanted to confirm to herself, to this meeting, and to the people of South Africa that before the sun sets today, a letter would have landed in Mr. Ramaphosa's office, where we'll be asking for her suspension pending the investigation into her fitness to hold office. We will invoke the relevant sections in the Constitution and in the NPA Act. Thank you very much, Chair.
We'll take that as your submission, Honorable Mani.
Chair, but why was that announcement important, really?
Honorable NTPP.
I have indeed taken note of that, Chair.
Yeah.
Chair, on the issue of the Honorable Paulson's question regarding the deportation and asking the NPA to ensure that he remains in this country pending appeal processes, but that we also ensure that he, as he put it, I hope I wrote it down properly, stays out of harm's way, and that he's not. Now, that's not within the mandate of the National Prosecuting Authority. I explained when I mentioned the dilemma of appeal versus deportation earlier on, why there is no win-win situation. It is trying to make the best of a very, very complex situation. And at the end of the day, I think what the people of the country would feel is best for the country, in terms of, if one has to take note of the way many honorable members have expressed their views concerning Mr. Omotoso. So there's no good situation here. And as I explained, the appeal processes could take years, and it could also end in a success in the appeal being granted or not. And it's another risk. And in that time, there's no way that the NPA can ensure that that Mr. Omotoso legally, and we certainly do things legally, that he is kept, that people are protected from him. Let's put it that way. So we are coordinating within the JCPS cluster and doing what we think will be the better of two difficult situations. And so the Department of Home Affairs is proceeding with its processes, and we are supporting as appropriate. And we will make sure that we expedite the issue to the extent that we can of the appeal. But I can take it no further than that. And I just want to make one point very, very clear, is that the NPA does not investigate, except for the very limited mandate of the IDAC. We prosecute only. Thank you, Chair.
Thank you very much, NTPP. Thank you very much, members, for the inputs and that you have forwarded in the meeting. NTPP, we will wish you luck for the appeal, and wishing that you are going to expedite the matter. All we want to see as members of Parliament and the representative of the people is justice being done and seen to be done to the victims, which have laid complaints against the church leader, who appears to be a very problematic character in terms of our legal system. I think we bear an obligation to close down and clamp down any form of criminality. We'll wish you luck. Of course, we'll be monitoring the process very closely, for we draw an interest in seeing justice being served. So thank you very much for appearing here. The Department of Justice, which we are going to meet DDGPLA Tuesday next week for a different matter of the TRC, with you and DPP as well Tuesday. We have an appointment with you on the TRC matters. Members, thank you very much for the insightful engagement. Very robust and trying to solicit relevant answers to the issues that which the entire justice system is facing in South Africa. So thank you very much. Tomorrow, NTPP, I will be attending the funeral of the prosecutor that was assassinated in Mthatha, the Eastern Cape. I'm not sure if there is anyone from the National Office that will be in attendance.
Advocate Mzanyati will be there. Thank you
very much, NTPP. For now, members, colleagues, thank you very much. The meeting is adjourned and we wish you a very pleasant weekend. Thank you very much. The meeting is adjourned.
Long live the chair. Long live the chair.
Recording stopped.